Morning, everybody. Doug, who are we looking for to bring in?
Good morning, Judge. We should have a Richard Yount and an Allison Johnson.
Okay, got both of them. Let me get them in.
Perfect. And thank you and Brittany for setting this up for us.
Sure, absolutely. Happy to do it. Okay, thank you. Miss Johnson, you can hear me?
Yes, sir.
Okay. Do y'all have copies of the oath in front of you?
Yes.
Yes, sir.
Okay. Miss Johnson, you're kind of lagging behind. Your voice is lagging behind the audio, so we may have to go a little slower when we do this. I tell everybody.
Hang on, I'll run over to Doug's office.
Okay, we've got time. We'll wait for you. Okay, can you hear me now?
Yes, sir.
Okay, that's much better. So
Okay, sorry about that.
that's all right. I tell everybody every time I swear in new advocates, I tell them two things. First one is you have to know it's a very important job that you're doing because this oath that you're taking today is twice as long as the oath to become president of the United States. So
wow.
that's got to tell you
I
how
saw
important
that.
it is.
Yes.
And then the other thing I tell people is it does happen when I say I state your name. State your name. Don't say state your name. So we occasionally have someone that says that too. So we'll get through this. I'll try to go slow. And I'm glad you have it in front of you. That makes it go a little easier. I don't make you keep your hand raised because, as I said, it is quite a lengthy oath. So if you would then repeat after me. I state your name.
Richard
Allison
Yount.
Johnson.
Do solemnly promise and pledge
Do
Do
solemnly
promise and pledge
that I will faithfully execute the duties
that I will
that I will
faithfully execute the duties
execute the duties
of a court-appointed special advocate
of a
as
court-appointed special
court-appointed
advocate
special advocate
as assigned and appointed
as
as
assigned
assigned and appointed
by the district and county courts
by the district and county courts
of Armstrong,
of Armstrong,
Armstrong,
Briscoe,
Briscoe,
Carson,
Carson,
Hutchinson,
Hutchison,
Potter,
Potter,
Randall,
Randall,
and Swisher courts,
and Swisher courts,
state of Texas,
state of Texas,
and will to the best of my ability
and do to the
and
best
will
of
to
my
the best of my
ability
ability
preserve the confidentiality
preserve the confidentiality
of any and all information received,
of any and all information received,
holding all such matters in the strictest confidence,
holding all such matters in the strictest of confidence,
to be divulged only in accordance
to be divulged only in accordance
with the rules and guidelines of the courts,
with the rules and guidelines of the courts,
and then only to the furtherance
and
and only to the furtherance
of the best interest of the child or children.
to the best interests of the child or
or
children.
children.
All right, one more paragraph, we'll get through this.
Mhm.
Okay, and I furthermore promise and pledge
And I furthermore promise and pledge
that as a court-appointed special advocate
that as a court-appointed special
advocate
in carrying out my duties as such,
in carrying out my duties and such,
and carrying out my duties as such,
the paramount concern will be
my paramount concern will be
the best interests of the child or children
the best interests of the child or children
to whom I may be assigned.
to whom I may be assigned.
So help me God.
So help me God.
Okay, congratulations. We got through it.
Thank you.
I look forward to working with both of you. I tell you, you can't believe how important it is what you do. We have so many of these kiddos. The only one they trust in the whole case is usually the CASA advocate, if anybody. So you make a big difference. I hear it all the time from the older kiddos that we're lucky enough to appoint CASAs for. They tell us that thank you so much for appointing them. They help me so much. So anytime you want to, you're welcome to stay on. I only have one hearing this morning. You're welcome if you want to kind of see how it works, just stay on and listen in. If not, anytime you want to kind of get a feel for my court and Judge Baker's court, you'll be in her court too. I don't know if y'all know that's my wife. So
Yes, sir.
so you're always welcome to watch us on YouTube. If we're not on, it's because there's something that's kind of, there's something about the case that we don't think we need to be broadcasting to everybody. But you can always go on to Northern Panhandle Child Protection Court on YouTube and watch us if you want to. And I forget what Carrie's court is called. I can't even remember what her court's called, but
Plains Children's Court.
Yeah, I believe.
Yeah. So if you ever want to kind of just get a feel for things, you're welcome to join us that way. So, okay, congratulations. I look
Thank you, sir.
forward to seeing you on court.
Thank you.
Okay.
Thank you, Judge. Thank you,
Yeah,
Brittany.
good to see you again.
See you
Yeah, good
guys.
seeing you.
No
Take it
problem.
easy.
Congratulations. Have a good day.
Judge, before we get started, I just want to commend CASA on the email that they sent me. A very, very detailed, very thorough email. I want to appreciate their work just before we get that out of the way.
Yeah, good. Good to hear.
Thank you, sir.
Swore in two new CASA volunteers just a minute ago.
Oh, outstanding. Outstanding. They do great work.
They do. Okay, I'll open
Thank
that
you.
back up.
Thank you. We appreciate it.
Okay, where do we stand?
Judge, I believe that I can announce an agreement at this time. I don't know if you've called the case though, so.
Oh, I haven't. No, you're right. Correct. Thank you. All right, I will call Gray County case. Albie's with us for the department. CASA is with us. Mr. Barfield's with us representing the child. Mr. Pirtle's with us representing the father. Mr. Braylock, who's with us. Blaylock, I'm sorry. And Ms. Gomez is with us representing the mother, Ms. Lambright, who's with us. I don't have anybody in the waiting room. So, Mr. Albie, you can announce the agreement.
Thank you, Your Honor. At this time, I think the parties have agreed that the Texas Department of Family Protective Services will remain as temporary managing conservator of the child. Everly will continue in her current placement, which is in Clarendon. That the parents, Brooklyn and Rance, will agree to work services. Mr. Blaylock he works shift work for SWM in Pampa, and we've agreed that we will try to accommodate his work schedule and provide him services, including any virtual services that may be available. In addition, Your Honor, the parents will continue with their current visitation with the child. It will continue to be supervised. However, if it's the child's great grandparents, if they agreed to be a supervising party, we would have no objections to them being the supervising party.
All right. Is that great grandparents? Is that the placement?
Current placement, yes, sir.
Paternal or maternal?
I believe it's on the maternal side, Your Honor.
Okay. And you said in Clarendon?
Correct.
Okay. All right. Ms. Gomez, you've heard Mr. Albie announce the agreement. Is that your client's agreement?
Yes, Your Honor.
All right. Mr. Pirtle, is that your client's agreement?
Yes, Judge.
Mr. Barfield, you're in agreement?
I'm in agreement with visitation. If the placement agrees to supervise, I'm fine with that. If not, then obviously we need suitable supervision by another individual. Other than that, yeah, I'm in agreement.
Okay. And CASA, you've heard the agreement. Does CASA have anything to add?
We have nothing more to add, Your Honor.
Okay. All right, then. I will approve that agreement then. I will continue the department's temporary managing conservator, continue the current placement. I'm fine. I'm in agreement. I'm fine with the great grandparents to supervise visits if they will. That's better for the child, the parents, and we obviously wouldn't have placed the child with them if we had any concerns. So, okay. I appreciate y'all working that out. Our next hearing will be the status hearing where we'll talk about services for the parents. That will be on May 21st, 2025. It will be by Zoom, just like today's hearings, so parties and attorneys can go on the court's online docket a day or two before May 21st to see what time we'll have that hearing. All right. Luckily, this is our only hearing we had today, so we will stand in recess. Everybody have a good weekend.
Thank you, Judge. I'm really upset I don't get to spend all morning with you, Judge.
I could tell. I could see it in your face.
Thank you, Judge.
Graham?
Thank y'all.
Judge Graham,
Yes.
it's a case, an issue not related to the case. If I could just stay and talk to you and Miss Forbes for a second, if she's here.
Yeah. Let me go ahead. I'll get us off YouTube, and then once everybody drops off, we'll be back.
Yes, sir.
Good afternoon.
I was waiting to see if we got some more attorneys in, our parents, and we've got a full afternoon, so we're not going to be able to wait on them. I will go ahead and call Randall County case. We're here on an initial permanency hearing. Ms. Gutierrez is with us from the department. Ms. Wiggins is with us representing the child. Ms. Grant represents the children. She is not with us. The alleged father, Damian Williamson, is not with us. And mother, Jolie Simmons, is not with us. As I said, this case was set for 12:30. It's now 12:42. we have a full afternoon. So I do have Juan Heredia and Kevin Foster in the waiting room.
Your Honor, if I could ask for clarification, did you say Stacy Grant is not in the hearing right now?
No, she's not. She's not in the waiting room.
Okay, would it be possible for, I think might have her cell phone number, or if,
Oh, Brittany's got them. She can try her. I'm really getting irritated at having to call lawyers to tell them to show up in court. So I'm
Yes,
probably
Your
not going
Honor,
to
I
do that
understand.
much longer.
I'm already in the process of trying to get a hold of her. Thank you, though, Teresa.
Sure.
And Judge, Kevin is my witness.
Okay.
I did have a motion
Mhm.
as well. And so just whenever we're about to hear that.
All right. Well, that's up to you. If we can we do it all at the same time? Or do you want to get that out of the way first?
I think we can probably do it at the same time because I'm going to be asking the worker
Okay.
questions as well concerning that.
All right. Well, let's go ahead and get started, and I'll watch the waiting room for Miss Grant and either of the two parents. So, all right, Miss Gutierrez, you may proceed.
Thank you, Your Honor. The department calls, let me see, I think it's Juan Heredia as its witness.
All right, let's get him in. Thank you, Miss Gutierrez.
Thank you, Your Honor. Juan, who do you work for?
St. Francis Ministries.
And are you the caseworker assigned to the children?
I am.
And did you prepare and file a court report dated April 10th of 2025?
Yes, I did.
And was it filed that day?
Yes.
Great. Mr. Heredia, just a moment. Your Honor, we ask that the court take judicial notice of that court report.
All right, so noted, and I read that report.
Okay, thank you. Juan, can we get some updates on how Desmond is doing in his placement?
Desmond is doing very well in his placement. He is active, energetic little boy. He likes playing on his iPad, watching videos and cartoons. Likes being sung to, having interaction and stuff with his placement. He's doing very well.
For the record, Miss Grant has just joined us.
Okay, great.
Go ahead, Miss Gutierrez. Miss Grant, your client's not present, just so you'll know. Go ahead, Miss Gutierrez.
Thank you, Your Honor. Okay. And Juan, can I get some updates on how the child Hope is doing in that placement?
Hope is also doing very well. She's 6-month-old infant. So she's at the point right now where she is very curious about the world around her. She's also doing very well, very attached with her placement. They are meeting her needs and pouring into her. And so she's doing very well, as well as a 6-month-old can be doing.
Okay. And how old is Desmond?
Desmond is approximately 21 months. He's almost 2 years old.
Okay, great. And where is their placement located?
Their placement is located just outside of Austin.
And what city are they in?
That would be in Cedar Park, I believe.
Okay. Let's see here. And I apologize if your court report states that they are in Harris County.
In Harris County, I apologize. Yes, ma'am. I apologize on that.
Okay, and so are they in Cypress, Texas, or are they in Cedar Park, Texas?
In Cypress, excuse me. Yes, ma'am.
Okay, thank you. So they're actually in Houston area, correct?
Yes, ma'am.
And about how far away driving is Amarillo, Texas from Houston, Texas, or Cypress, Texas, rather?
It's going to be approximately almost a 10-hour drive.
Okay.
Depending on the stops and whatnot, between almost 10 hours.
Thank you. How is Jolie Simmons doing on her service plan?
Jolie Simmons has not had any progress on her service plan.
Is she complying with Texas, with them communicating with you?
She has been communicating with me and maintained contact.
Has she But is she complying with drug testing?
She has been going for her drug screens.
And briefly remind the court the reasons for removal.
The reasons for removal were due to neglectful supervision and forgive me, it's been a long morning. I apologize. It was for neglectful supervision and primarily neglectful supervision and the conditions in the home.
Okay. And likewise, has Miss Simmons also admitted to any drug use with you?
She has not admitted to any, but she has tested positive on her drug screens.
And that's marijuana, is that correct?
Yes, it is.
Okay. Now, was it the condition of the home that caused the removal?
Yes, ma'am, for unsanitary conditions.
Have you been able to visit the home where Miss Simmons is currently living?
Yes, I have.
And can you tell us about the condition of that home?
That condition is improved from the home that the children were initially removed from.
Okay.
However, she lacks furniture for the children. She does not have beds for the children. It is a 2-bedroom apartment that she shares with roommates, in which Ms. Simmons is located in one of the bedrooms with just a full-size bed.
Okay. And in regards to her visitation with the children, is she completing visitation with the children?
Her visits are scheduled for 1 hour per week. She gets a virtual visit, and those are split up into 2 half-hour visits due to the age of the children and being able to keep their attention. Jolie has been in on visits. However, she has not been very active during the visits. She doesn't interact very much with the children. And even after being coached and helped with how to maintain better how do you say it, in order to have, to keep the children's attention and whatnot, she still has not done very well with that.
Okay, so right now her visitation is 2 visits per week, and each visit is 30 minutes. Is that correct?
Yes.
And these visits are virtual. Is that correct?
Yes.
And and Hope is only what, 7 or 8 months old? How old is Hope?
She's 6 months old.
And how old is Desmond?
Desmond is 21 months.
Considering the age of the children, are you concerned about whether or not virtual visitation for a 6-month-old infant and a 1.5-year-old toddler is going to create any sort of bond between the mother and children?
It is going to make it difficult for the children to bond with their mother or their parent or any family that they have contact with. And
would you agree that if there had been a bond or whatever bond was present at the time of the removal, it would be difficult to sustain that bond through virtual visitation with children this age?
Yes.
And statutorily, the department is required to make reasonable efforts to reunify the family. Would you agree?
Yes.
And in order to do that, do you think in-person visitation would be more reasonable as far as an effort to reunify the family?
Yes.
And what is St. Francis planning regarding the placement of the children and their physical location?
St. Francis had secured an in-region placement for the children that was adoption motivated in the event that the children were not able to be returned to their parents should the parents not comply or meet the requirements of their plan. the idea was that with an in-region placement, the children would be able to have in-person visits with their mother.
And would that help create or maintain any bond that they have with the mother?
Yes, it would.
And in your opinion, is that a reasonable effort to reunify the family as we are statutorily required to do?
Yes, it is.
Regarding Damian Williamson, have you had any contact with Damian Williamson?
No, I have not. Damian Williamson has been absent since the beginning of the case. There was initial contact with him, and for the past almost 6 months, there has been no contact with him at all. We have been unable to locate him.
Going back briefly to Ms. Simmons, the last court order made an order that, or rather, in the last court order, it had a provision that the mother was to complete another substance abuse assessment in the event she tested positive. Is that correct?
Yes.
And was the mother informed of her drug screen results, the most recent ones?
Yes, she was.
And what date was that drug screen? What date was she informed of that drug screen result?
The last drug screen that she had was for March 31st, and she was informed approximately just before this report was completed, so around the 10th of April.
And did you ask her to go ahead and complete that second substance abuse assessment?
She was asked to, and she did not comply.
Now, has Ms. Simmons mentioned any other possible fathers for the children?
No, she has not.
And I think you said that Mr. Williamson was in contact at the beginning of the case, but not since then. Is that correct?
That is correct.
And to your knowledge, has he asked for any genetic testing?
Not to my knowledge.
And is he maintaining his address and phone number information updated with you?
No.
Do you have any information of where he might be?
No, I don't.
Okay. Is there any information from his relatives?
No, there was not. Initially, there had been some contact with his sister, but his sister has now not been able to be contacted either.
Okay. And when you did have contact with her, did she indicate that he was homeless?
That he was homeless, that was the last report they had. They hadn't been able to get in contact with him at his last known residence.
Okay. Are we asking for any changes in visitation today?
No.
Are we asking the court, though, to allow that placement change to the Panhandle area to facilitate in-person visitation for the mother?
Yes.
And additionally, are we doing that as a reasonable effort to reunify the family?
Yes.
Now, in addition to asking for that placement change to the Panhandle area, can you please identify the department's reasonable efforts to reunify the family?
The other reasonable efforts the department has made are a tailored plan of service was created for the parents to hopefully mitigate the reasons for removal for the children. A visitation plan was created for Jolie Simmons for her to maintain her familial bond and contact with the children.
Okay. And does Ms. Simmons have her own transportation?
No, she does not.
And are we offering her transportation to help her with services?
Yes.
And those virtual visitations, is she able to do those on her own, or does she need our help as well?
She's been able to do them on her own.
Okay. Now, in the event the children were physically closer, like in the Panhandle area, would St. Francis be willing to provide transportation to the mother for those in-person visits?
Yes, we would.
Are there any other requests we have for the court?
No, ma'am.
At this time, would it be contrary to the welfare of the children to be returned to either parent today?
Yes, it would.
And would it pose a continuing danger to their physical health or safety?
Yes, it would.
I pass the witness.
Ms. Grant, questions?
Has Jolie Simmons given you any reason to need to request additional services in this case today?
No, she has not.
So the service plan as filed with the court is still the adequate plan to affect reunification should she complete the plan, correct?
Yes.
Pass the witness, Your Honor.
Ms. Wiggins?
Thank you, Judge. One, in regards to the current placement of the children were placed there on November 1st of 2024. Is that correct?
Yes.
And so that was right after the removal of the children. Is that right?
Yes.
And they've been there 5 months.
Yes.
And now you're asking actually for the children to move potentially to Lubbock, not the Panhandle. Is that right?
Yes.
And in regards to the children, wouldn't you say that Hope, when she moved there, she was 1 month old? Is that right?
Yes.
And so basically the caregivers that she's had have been basically the majority of her life. Is that right?
Yes. And essentially,
And
that's all she's known.
that's all she's known. And would you say that she's very bonded with them?
Yes, she is.
And in regards to the mother, you indicated on your court report that the family reunification is still the goal. Is that correct?
Yes.
But yet we're 6 months into the case and the mother has only done 2 parenting classes and 2 counseling sessions. Is that a fair statement?
That is correct.
And she actually missed her last visitation. Is that right?
Yes, she did.
And that's just a phone call and she's missed that.
Yes.
And in regards to her housing, when was the last time you had a home visit with the mother?
On the 22nd of April.
Did she inform you that she would have to be changing her address because she was being evicted?
Yes, she did.
So now she's being evicted from this location where she didn't even have adequate resources for the children. Is that a fair statement?
Yes.
And did she also indicate that her phone was being disconnected?
Yes, she did.
Okay. Did she indicate how she was going to reach out to the department or reach out to the kids or do anything that she needs for this case?
At the time, she indicated that she was going to reach out to the visit monitor to let them know that she was going to be unavailable possibly for her visit this last Thursday, and that she was trying to get a job to see about having her phone services continued.
And has she had a job in the last 5 months?
She had one, which she worked for approximately 3 weeks and then was let go from that job.
And you indicated that she hasn't complied with her second OSAR. Did she do a first OSAR?
She had done one with the previous caseworker.
And did that recommend any services at the time?
No, ma'am.
Okay. But since that, she's continued use from your understanding?
Yes.
Okay. And and you anticipate if she does a second OSAR potentially being a drug treatment?
Yes.
Now, in regards to the father, you've indicated that you have had no contact with him. Is that correct?
Yes.
And he's never had any visitation with the children. Is that right?
That is correct.
And in regards to the place where the children are currently, if the parental rights were altered or terminated, are they a long-term placement or foster placement for the children?
Yes, they are.
Okay, I'll pass the witness, Judge.
All right, thank you. Anyone else have questions for Mr. Heredia? All right. Mr. Heredia, I was breaking up that Ms. Williams' last question. Is the current placement interested in adoption if the parents are terminated?
Yes, they are, Your Honor.
So the only reason the department's asking to move him would be to accommodate the mother for her visitation. Your report said that she's not been consistent in visitation. Has she missed more than the last visit?
There's been visits where she has logged on late or she is cut out early.
Okay. All right. Thank you. All right then, Ms. Gutierrez, do you have any other witnesses?
I have one more question for Juan. Juan, are we asking for any drug screens to be ordered today?
Yes.
Which ones?
The drug screens for Jolie Simmons.
And would that be a urinalysis or a urinalysis and a hair follicle?
But urinalysis, since hair follicle was just done at the end of March.
Okay. I pass the witness again, Your Honor.
Anyone else questions? All right, then, Ms. Gutierrez, any other witnesses?
No other witnesses, Your Honor. The department rests. We do ask for the court to make a finding of reasonable efforts to reunify and our attempt to move the children closer, as well as the family plans of service, visitation, and offering transportation to the mother for services.
Okay. All right, then, Ms. Grant, any witnesses?
No, Your Honor, my only witness was going to be Jolie Simmons, so I would just ask for the record that the court verify she has still not entered the waiting room at this time.
She has not, and she hasn't been in the waiting room since we started, or even before we started, so.
Thank you, Your Honor. No witnesses, I rest.
All right, thank you. All right, Ms. Wiggins, any witnesses?
Judge, I'd call Kevin Boucher real quickly.
Kevin Foster?
I don't think that's his last name, but he's a foster.
Oh, Foster, okay, it's Kevin, foster parent.
Yeah.
I thought foster parent was kind of a funny last name.
Right.
Sir, Ms. Wiggins, you may proceed.
Thank you, Judge. And I'll just call you Kevin too, if you don't mind. Kevin, are you the foster placement?
Yes, I am.
And how long have you had Hope and Desmond?
Since November of last year. So.
And how are the children doing in your home?
They are doing very well.
And if the parental rights were altered or terminated, is it your intention to be a permanent placement for the two children?
Yes.
And in regards to the children, do you believe that you are able to take care of all of their current needs?
Yes, I do.
And do you feel like you are bonded to the children?
Yes.
And do you feel like they are bonded to you?
I do, yes.
And in fact, Hope has basically known you as her parent for 5 months out of her 6 months of life. Is that right?
That is correct, yes.
Okay. Now, in regards to visitation, do you facilitate those when called upon?
Yes, we do.
And is visitation consistent with the mom?
We are scheduled for twice a week.
Okay. And do you make twice a week? Or you make twice a week? Does she make twice a week?
Not every week, no.
Okay. And so therefore you would basically call that a little inconsistent. Is that right? Fair statement?
That's a fair statement, yes.
Okay. All right. And do you believe the children are thriving with you?
I do, yes.
Okay. I'll pass the witness, Judge.
Ms. Gutierrez?
No questions, Your Honor.
All right, Ms. Grant?
Sorry, I was muted. No questions, Your Honor.
All right, thank you. Anything else of Kevin from anybody?
No, Your Honor. Thank you.
All right. Sir, you can, unless somebody objects, you can I can go ahead and remove you and you can go about your afternoon's business, or if you want to listen in, I don't have a problem if nobody objects. Does anybody object?
I don't object, Your Honor.
No
Okay.
objection.
So it's up to you, Mr. Boucher, if you want to stay on just to hear what's going on.
Yes, I'd like to stay, yes.
Okay, if you can turn off your camera if you want to, or you can just sit there like you are. It doesn't bother me. Either way is fine with me.
Yes, thank you.
All right, then, Ms. Wiggins, any other witnesses?
No other witnesses, Judge. Rest.
All right, so everyone rest and close?
Yes, sir.
We do, Your Honor. I'm just asking for those findings of reasonable efforts as well.
All right, I will make the finding that the department's made reasonable efforts to reunify the child with the mother.
Thank you.
Okay, Ms. Wiggins, recommendations. I've read your motion. I know you're asking that the children not be moved. Anything
That's
else?
correct, Judge. That's my
Okay.
That's
All
my
right.
recommendation, that the department remain temporary managing conservator and that the children's placement be continued and approved. I don't think at 5 months along in a case where we have an uncooperative parent who is not even exercising phone visitation to move the children, I do not believe it's in their best interest to be moved, and I would ask that they remain in their current placement.
All right. And this week it'll be 6 months, not 5. So,
Yes, Judge.
all right, then, based on the what I've heard today, then I'm going to continue the department's temporary managing conservator, continue the children's current placement. I'll order that Miss Simmons' visitation be suspended until she provides the department with a negative hair strand and UA drug screen. And if she can do that, then it will go back to the virtual visits as they're currently scheduled. I'll order both parents to UA drug screen by 4 p.m. today, wherever they're located. And I will enter an order that the children not be moved from their current placement without a prior court order. So that, in effect, even though your motion didn't ask for a finding, I'm granting the motion that the children will not be removed. Okay. I'm questioning whether or not we should set the next hearing for a final. I haven't seen anything to indicate that that needs to go on any longer than it has to. So I'll leave it where it said. It was the next permanency was going to be on August 18th. I'll go ahead and leave that current date set, but I'm going to make that a final. If Miss Simmons gets on board and starts doing her services, then we can reevaluate that. We can always treat that final on August 18th as another permanency hearing. So, okay, that hearing will be by Zoom, just like today's hearing. So parties and attorneys can go on the court's online docket a day or two before August 18th to see what time that hearing will take place. Mr. Boucher, I don't know if anyone's told you, but we broadcast these live on YouTube under Northern Panhandle Child Protection Court. Anytime there's a hearing set, they should notify you, and you're welcome to, if you're not going to testify, then you're welcome to join in on that and attend the hearings that way.
Okay, thank you.
Ms. Gutierrez is with us for the department. Ms. Wiggins is with us representing the children. Mr. Hill's with us representing any unknown father or an alleged father, Damian Williamson. He is not with us, not in the waiting room. Mr. Hill, were you expecting him?
No, sir.
Okay. And then Ms. Grant represents the mother, Ms. Simmons. She's not in the waiting room. Ms. Grant, were you expecting her?
No, sir. We've lost her since July of 2025, and the caseworker as well has
Okay.
lost her.
All right, thank you. Okay, I have Marcia Fowler and Juan Heredia in the waiting room.
Juan Heredia will be my caseworker, my representative for the entire case, Your Honor.
Okay, let's get him in.
And Marcia Fowler is my first witness. I should have two additional witnesses or one additional witness. Let me email her real quick if I could have a moment.
Sure. Ms. Gutierrez, Kathy showed up in the waiting room. She's a supervisor. Do you want her in now? Or is she going to be a witness?
She's going to be my second witness. So if nobody's invoking the rule, I would like her to come in.
Does anybody want to invoke the rule?
No, sir.
No,
Okay.
sir.
All right, I'll go ahead and let her in.
Thank you, counsel. Thank you, Your Honor.
Okay, I think we're ready to go. You may proceed.
Thank you, Your Honor. The department calls Marcia Fowler as its witness.
Okay, I swore in, so we're ready.
Thank you, Your Honor. Marcia, who do you work for?
I work for the Department of Family and Protective Services, Adult Protection Services.
Okay. And are you a previous employee of the Child Protection Services section?
Yes, ma'am.
And how many years total do you have with the Department of Family and Protective Services?
Almost 10.
Okay, great. Thank you. On October 11th, 2024, did you visit the home of Miss Jolie Simmons?
Yes, ma'am.
What was the purpose of your visit that day?
We had to report the physical neglect of, I guess it would be the grandmother.
Okay. And were you able to enter the home of Jolie Simmons?
Yes.
Thank you. Now, once you were in the home, what are some of your duties as a part of assessing the environment?
Oh, well, we assess the home, determine the cleanliness, look for, of course, pest control, if there's food in the home.
Okay. And does that require that you walk throughout the home?
Yes, ma'am.
In walking throughout the home where Jolie Simmons resided, did you identify any of her children?
Yes, ma'am.
And how many children did she have there?
2. There was the little boy, he was in the crib or in the playpen in the living room because he had COVID at that time. And the mother was with the newborn in her bedroom to keep the newborn away from the little boy.
And did she identify both children as her own children?
Yes, ma'am.
In walking through the home, what concerns did you identify?
The home was extremely hoarded, very dirty. There was food on all over the floors, stains. it looked like they have not cleaned the home in a very long time. Where the child was sleeping in the playpen in the living room, it was stuffed between a bunch of things, the hoarded materials. And then the aunt was sleeping on the couch watching him.
Now, when you say hoarded things, do you mean that there were stacks of items
Yes,
in the
ma'am.
home?
Yes, ma'am.
And were there clear walkways in the home?
Yes, ma'am. There was a clear pathway.
Okay. However, was that pathway through clutter?
Yes, ma'am.
And did you identify that as a safety concern for small children?
No, yes, ma'am.
Additionally, were there any concerning odors in the home?
Yes, ma'am. There was strong odors. Also, when I went into the grandmother's room and throughout the house, there were cockroaches crawling all over the walls. And when our client, the grandmother, opened up her pill tote with her pills in it, the cockroaches just come swarming out there. I mean, there was lots of them.
Okay. Did you have any concerns with a high chair that was in the home as well?
Yes, it looked like they hadn't cleaned up the food around it in quite some time.
And is that a concern as far as health?
Yes, ma'am.
Okay. Did you determine this environment to be neglectful?
Yes, ma'am. We did validate on my client. Yes.
And what was the validation result?
Valid for the safety concerns of the home with the hoarding and the pest control.
Okay. Pass the witness.
Ms. Grant?
Ma'am, did you contact Child Protective Services after your visit of the home?
Your Honor, I'm going to object. Any reporting would be confidential.
Sustained.
Ma'am, did you leave the home comfortable that other measures would be taken to assess the children?
Yes, ma'am.
Pass the witness, Judge.
Mr. Hill?
No question, Your Honor.
Ms. Wiggins?
No question, Judge.
All right. Anything further from Ms. Fowler?
Nothing further, Your Honor. We ask that she be released.
Okay. Thank you for your testimony, Ms. Fowler. Good to see you again. It's been a long time.
You too. Yes, sir, it is.
I'll release you so you can go back to your afternoon's business.
Thank you. Y'all have a great day.
You too.
And Your Honor, I actually have a second witness that is before Ms. Jones' name, Mercedes Hodge. Is she in the waiting room?
No, the only person in the waiting room is Jay Scales that's in one of our other hearings.
Okay, thank you, Your Honor. Ms. Jones?
I haven't sworn her yet, so.
Oh, okay. I'm not calling her as a witness yet, Your Honor. I was going
sorry.
to ask her to contact Mercedes Hodge, please.
Okay.
And is the alleged father of both children, Damian Williamson.
Yes.
Can you tell us what those intake allegations were on October 10th of 2024?
There was concerns of the cleanliness of the home, that there may be feces and clutter, and that the children didn't have a proper area to be.
And based on that intake, did you make contact with Jolie Simmons on October 10th of 2024?
Yes.
And was Ms. Simmons at the home?
Yes.
Thank you. And who opened the door to you?
I believe there was another gentleman there as well. But
That's
Jolie,
fine.
I did eventually speak with Jolie.
Okay. And when speaking with Jolie, did you speak with her outside of the home?
Yes, on the porch.
And what occurred while you were beginning to speak with Ms. Simmons?
The grandparents were trying to, I believe who were the grandparents, there were two individuals there who didn't let me know who they were trying to tell me not to speak to Jolie. But once I figured out that she was not a minor, that she was of age, then I told them that I needed to speak with her directly.
Okay. And without telling me what exactly he said, what behavior did the man display towards you?
He was yelling, he was getting in my face, and trying to tell me like that I didn't need to be there, that I didn't have a reason to be there, and really just combative at that time.
Okay. And did you inform all the parties that you were there and needed to speak with Ms. Simmons since she was an adult?
Yes.
Okay. And at that point, did Ms. Simmons come out on the porch?
Yes.
And what occurred when you attempted to interview Ms. Simmons about the intake allegations?
She was not cooperative. She did give me, the names and the birthdays of the children so that I could verify that I was talking to the right family and the right people. She said they were in the home, but that she really wasn't willing to cooperate or be interviewed at that time.
Okay. And did she deny you entry into the home?
Yes.
Thank you. And did she refuse any photographs?
Yes.
Okay. And did you, in your attempt to interview Ms. Simmons, did you explain what the intake allegations were?
Yes.
However, she continued, is it correct that she refused to continue to speak with you?
Correct.
And at one point, did she ask you to leave her porch?
Yes.
Thank you. And then following that, on October 11th, 2024, did you speak with Adult Protection Services worker Marcia Fowler?
Yes.
And did she raise her concerns regarding the cleanliness and the safety of the environment of the home?
Yes.
Following that, on October 14th of 2024, did you speak with Damian Williamson over the phone?
Yes.
Did you share the intake allegations with him?
Yes.
How did he respond?
He was not cooperative. I think he had history with the department, so he wasn't willing to cooperate with us.
Okay. Did he also say he would send you his attorney's information to reach out to him?
Yes, but I never received any.
Okay. And did he also instruct you not to contact him directly?
Yes.
Thank you. Now, following that, did you reach out to Ms. Simmons again on October 18th of 2024?
Yes.
And was that to see if she had changed her mind and would cooperate?
Yes.
How did she respond?
She was still not willing to cooperate with the case.
Okay, thank you. And then October 30th, Investigator Bailey reached out to Ms. Simmons again. Is that correct?
Yes.
And did Ms. Simmons again refuse to cooperate?
Yes.
Now, after your October 18th, 2024 interview with Ms. Simmons, did you next go on leave?
Yes, I did.
And were you on leave when the removal occurred?
I was, yes.
Okay. So were you concerned at this point in your investigation that Ms. Simmons was not cooperating?
Yes.
And were you concerned about the potential neglectful environment for these children?
Yes.
Would you characterize both parents, both Mr. Williamson and Ms. Simmons, as uncooperative during your investigation?
Yes.
And if parents are uncooperative, does that rule out some alternatives to removal?
Yes.
Would it rule out a parent-child safety placements for the parents to work a case through non-legal intervention?
Yes.
Does it also rule out the family-based safety services case or section, which would provide them services, again, without legal intervention?
Yes.
And is that because both of those are dependent on parental cooperation?
Yes.
I pass the witness.
Ms. Grant?
Ma'am, during your contact with Ms. Simmons in the investigation, did she ever identify any family that could take the children?
Not to my knowledge.
Okay. Pass the witness, Judge.
Mr. Hill?
No question, Your Honor.
Ms. Wiggins?
No question, Judge.
All right.
Excuse me.
If anyone has further questions, can Ms. Hodge be excused?
Yes.
No objection.
Okay. Ms. Hodge, thank you for your testimony. I'll remove you so you can go about your day's business.
Thank you.
Thank you.
The department next calls Kathy Jones as its witness.
Okay. Wiggins. I'm sorry, Ms. Gutierrez.
I don't mind if Ms. Wiggins takes over. Thank you, Your Honor. Kathy, who do you work for?
I'm a supervisor with the Texas Department of Family Protective Services.
And what do you do for them? And can you tell me what an investigative supervisor does?
I have a unit of 6 investigators that I oversee during the course of their investigative work and am, like, I guess, the approver of their cases.
Okay. And so were you the supervisor over this investigation?
Yes.
And as being the investigative supervisor over it, were you a part of the decision-making process for removal?
Yes.
Okay. Now, Ms. Hodge testified a little bit about why FBSS and a parent-child safety placement would not work in this case. Is that correct?
Yes.
As well, with Mr. Williamson not being cooperative during the investigation, did it rule him out as an alternative to removal?
Yes.
Did it also rule him out as potential placement for the children?
Yes.
Now, following the removal of the children, and that removal was done with orders, is that correct?
Yes.
Following that removal with orders, did you personally have a conversation with Damian Williamson on November 2nd of 2024 as outlined in the investigative report?
Yes.
And in that conversation with Mr. Williamson, what did he state in regards to the removal?
He stated that we didn't have facts to remove. He wanted the children to be with their mom. He didn't see a need for it.
Okay. Did he reiterate that he wanted to be left alone?
Yes.
Okay. Now with that situation, if both parents are being uncooperative, would a kick out order have resolved any of the safety issues for the children?
No.
Okay. And as well, did that further reinforce that legal intervention was necessary?
Yes.
Can you please identify the reasonable efforts the department took to prevent removal?
Well, we asked for family members to help to assist the mom. She wasn't cooperative. We had already worked family-based safety services with the family a year prior. They were not unsuccessful during that time. There was concerns that, with continued use of marijuana and with them just having a case closed with not being successful with family-based, we didn't feel like it was feasible to request the same things again.
And did the department determine that removal was necessary and that there is an immediate danger to the physical safety of the children?
Yes.
And was that because of the neglectful environment that they were in?
Yes, unsanitary. Yes.
Can you briefly go into some of the dangers of having children in a hoarding situation?
Due to the toddler's age and the home conditions being described as urine and debris on the floor, it would be unsafe for that child, as children that age put things in their mouth. And if there's feces or urine on the floor, that would be unsanitary and would cause a safety concern.
Additionally, is a neglectful environment dangerous for an infant as well?
It is.
Can you talk a little bit about that, please?
Just unsanitary with roach infestation and things like that. It can cause breathing issues for a child to be exposed to. I'm not sure what the bedding looked like, but if the bedding of the infant was unsanitary, that could cause a safety risk as well.
Okay, I pass the witness.
Ms. Grant?
At the time that you asked for identification of any family members who could take the children, were you provided any information by any party?
I don't believe so, Ms. Grant.
Thank you. Pass the witness, Your Honor.
Mr. Hill?
No questions.
Ms. Wiggins?
Ms. Jones, were you also made aware that potentially there was no food in the house either for the children? Was that reported to you?
I'm looking at on our bullets to get back with you.
Yes, sir.
It may have been part of the intake, but I don't. What's described in the referral is that the home was observed with a lot of trash, cluttered items, feces covering the floor, and that the 1-year-old or Desmond was on the floor. I'm unsure about food for the children, but that would be a concern if that were the case.
Okay, and obviously it was a concern that you couldn't go in and verify or look at all of the arrangements for the kids.
Correct. We were not permitted access into the home.
And given their ages of a newborn and a toddler, that would be very concerning for children.
It would be, yes.
I'll pass the witness, Judge.
Anyone else?
One follow-up question.
Okay.
Ms. Jones, do parents get initial visits and visitation between the time of removal and the adversary hearing?
Yes, ma'am, they do.
And to your knowledge, was Ms. Simmons given this visitation?
Yes, she was given an opportunity, yes.
Okay. And would you agree that would be an opportunity or a reasonable effort for the department to reunify the family even before the adversary hearing?
During that time, if safety could have been shored up, yes, ma'am, it would have been considered.
Okay. But does visitation between the parents, does that also help maintain the bond between the parents and child?
Yes, it does.
And is that important for reunification?
It is, yes.
All right, I pass the witness again, Your Honor.
Anyone else?
One follow-up, Judge. Did Miss Simmons exercise that visitation?
I do not know.
Thank you. Pass the witness, Judge.
Ms. Jones, at that time, were you the supervisor then?
I would have been up until the adversarial hearing, sir, and I can look back through my notes and maybe answer that question.
Well, that's all right. I mean, was that your role back then? Were you a supervisor or were you an investigator?
Oh, no, I was a supervisor.
Okay. Did you ever actually get in the home? Did you ever see any of the things that caused concern?
Our information was gathered from Marcia Fowler, the Adult Protective Services worker, who was given access to the home.
Okay. All right. Thank you. Okay. Do we need Ms. Jones to stay?
No, Your Honor, we should ask that she be released.
Okay.
No objection.
All right, Ms. Jones, I'll release you so you can go about your afternoon's business. Thank you for your testimony.
Thank you, sir.
Uh-huh. All right, Ms. Gutierrez.
Thank you, Your Honor. The department calls Juan Heredia as its witness.
Gutierrez.
Thank you, Your Honor. Juan, who do you work for?
Work for St. Francis Ministries.
And what do you do for them?
I am a permanency specialist.
And can you tell us briefly some of the duties of a permanency specialist?
A permanency specialist, when we get a case that comes over to us, we help to provide a service plan for the family members to try and mitigate any concerns or issues that have brought a child into care. We provide resources for the parents and for placement as well, with any needs that the child may have, along with the needs for the parents.
Okay. And did you create service plans for this case for Jolie Simmons and Damian Williamson?
One was created for them.
Thank you. And did those family plans of service aim to mitigate the reasons for removal?
Yes.
As well as, are they the department's reasonable effort to reunify the family?
Yes.
Are they reasonably tailored to the issues in the case?
Yes.
And very briefly, what were the issues in this case that you were tailoring services for?
The issues in the case were neglectful supervision and physical neglect pertaining to unsanitary and unkept home and living environment for the children.
Okay. For Jolie Simmons, can you identify 2 or 3 services that were unique to Jolie Simmons?
She needed to undergo a drug testing. And then if she were to test positive, she would have to undergo an OSAR evaluation to further assess the reasons for her drug use. She also needed to have stable employment, and she needed to provide a appropriate living environment.
Okay. And did you go over this family plan of service with Ms. Simmons?
Yes, I did.
All right. And so she was aware of what services she was responsible for completing. Is that correct?
Yes.
Your Honor, at this time, we offer petitioner's exhibit number 1, the status hearing order.
All right, objections?
No objection.
No objection.
All right, petitioner's one submitted.
Thank you, Your Honor. Juan, do you have petitioner's exhibit number? Do you have a copy of the status hearing order in front of you?
No, ma'am, I'm afraid I don't.
Your Honor, I apologize. If I could have just a moment to send this over to Juan.
Okay.
And while that is heading over to you, Mr. Heredia, is it correct that the family plans of service were made in order of the court in this status hearing?
Yes, ma'am.
And you had mentioned about Jolie Simmons in the event that she was positive that she would need to complete a substance abuse assessment through outreach screening assessment and referral. Is that correct?
Yes.
And is that outreach screening assessment and referral referred to as OSAR?
Yes, it is.
Thank you. And is that was that made in order of the status at the status hearing as well?
Yes, it was.
Have you received those emails yet?
Yes, ma'am.
It's rather just one email. If you could please pull it up, exhibit 1.
Okay.
And if you would please go to the family plan of service for Jolie Simmons.
Okay.
Can you please identify briefly each service that Jolie was ordered to complete and whether or not she successfully completed it?
Yes, ma'am. So she needed to complete drug testing. Initially, Jolie did do some testing, but she has stopped testing. She stopped testing in March of 2025. That was the last time that she tested for the department. She was also assigned to do a mental health and mental retardation evaluation. She never completed the evaluation.
And Your Honor, at this time, I offer petitioners exhibit number 2. They are the drug screens of Jolie Simmons with a business records affidavit.
All right. Objections?
No.
No objection.
All right, petitioners 2 is admitted.
Thank you, Your Honor. Now, Juan, you mentioned that Jolie stopped drug screening in March of 2025. Is that correct?
Yes, ma'am.
And prior to that, was she testing positive for marijuana?
Yes, she was.
And in fact, on March 31st of 2025, on a hair follicle, she was positive for marijuana metabolite. Is that correct?
Yes.
And with her failure to complete that mental health assessment that was on her service plan, did that cause you concern for her ability to provide a safe environment for the children?
Yes.
Okay, thank you. Now, did you give us a complete list of each service on her service plan and whether or not it was completed?
Let's see here. She also needed to do individual therapy. She was supposed to submit herself for
Okay.
an evaluation.
Okay, we're going one by one. You said she was supposed to do individual therapy, but you didn't say whether or not she did that.
I apologize, Your Honor. It's the file's jumping all over. I apologize for that. So she was supposed to do an evaluation, which she did not complete.
What
Okay.
type of evaluation?
It was a psychosocial evaluation.
Okay. Sorry to interrupt, Ms. Gutierrez.
That's okay. That's okay. I just want to make sure that we didn't accidentally skip anything. Juan, you had mentioned that she was ordered to do individual therapy. Did she complete that individual therapy?
No, she did not.
Okay. It looks like one of her testing requirements was to do an OSAR, that assessment. Did she complete that assessment?
No, she did not.
And going back to drug testing, you said she stopped drug screening for the department in March of 2025. Is that correct?
Yes.
Did you ask her to drug screen in April of 2025?
Yes.
Did she comply?
No, she did not.
Did you ask her to drug screen in May of 2025?
I was unable to contact her. She dropped off communication and she was unable to be reached via text or phone.
Okay. But going back to April, that was actually a court-ordered drug screen. Is that correct?
It was court ordered during the last hearing.
All right, Your Honor, we next offer petitioners exhibit number 3, a certified copy of the initial permanency hearing order from April of 2025.
Objections?
No objection.
Objection.
All right, the petitioner's 3 is admitted.
Thank you, Your Honor. We next ask the court to note that in that order, Ms. Simmons was ordered to urinalysis and hair follicle drug screen by April 28th of 2025 at 4 p.m.
All right, so noted.
Thank you, Your Honor. Let's see here. Now, Juan, she was also ordered to complete a rational behavior training service. Is that correct?
Yes, she was. She did not complete that either.
Okay. And you had mentioned parenting. Was that through Hope Choice?
Yes,
Okay. And that was incomplete as well, correct?
that is correct.
Now, you mentioned that she was ordered to do a mental health and mental retardation evaluation with Texas Panhandle Centers. Is that correct?
Yes.
Did she ever complete that?
No, she did not.
Okay. Now, in the service plan, to the left of where that service is identified is a section that says goals, correct?
Yes.
Can you tell us what that little section says in regards to why that mental health evaluation was important? And could you just read that little section to the left of? Okay.
Jolie will demonstrate the ability to care for her mental health by following recommendations from a mental health provider. Jolie will be able to demonstrate improved mental health by being able to complete her daily tasks.
Okay. And would you agree that that was directly important on her ability to provide a safe, clean environment for the children?
Yes.
Now, as far as visitation, is it correct that Jolie's visitation was to be suspended in the event she did not? Oh, let me do it this way. Hold on. Your Honor, I asked the court to note in Petitioner's Exhibit number 3, Section 8.2.
Okay, so noted.
Thank you, Your Honor. Now, one, in that section, it states that her visitation with the children is suspended until Jolie Simmons provide both a hair follicle drug screen that is negative for illicit substances and a urinalysis drug screen result that is negative for illicit substances. Is that correct?
Yes.
Okay. Did she complete those drug screens in April?
No, she did not.
Okay. And so at that point, her visits were effectively suspended. Would you agree?
Yes, that is correct.
Now, prior to her visits being suspended at the end of April 2025, was she having consistent visitation with the children?
Visits were provided for her consistently, but she was inconsistent in the visits. She would at times cancel the visits, or she would leave the visits early, or say that she had issues and not be able to join at all.
Thank you. Now, in June of 2025, did you ask her to drug screen?
Yes.
And did she comply?
No, she did not.
In July of 2025, did you ask her to drug screen?
Yes.
And did she comply?
No, she did not.
And we are now in August of 2025. Have you asked her to drug screen this month?
Not for this month.
Okay, thank you. Do you believe that Jolie at this point has missed visits for at least 4 months?
Yes.
Would you agree that she has not maintained a relationship with the children?
That is correct.
Would you agree that she has failed to visit them as well?
Yes.
Regarding Damian Williamson, he was ordered to do a family plan of service as well. Is that correct?
Yes.
However, he has not made an appearance in this case. Would you agree?
That is correct.
And has he completed any of those family plans of services?
No, ma'am.
Do you believe it's in the children's best interest that the mother's rights be terminated?
Yes, ma'am.
And do you believe that the mother can or cannot provide a safe and healthy environment for the children?
She cannot provide a safe and healthy environment for the children.
Do you believe that the department has made reasonable efforts to reunify with the family?
Yes.
Can you please go into great detail about the reasonable efforts the department has taken to reunify the family?
A tailored family plan of service was created for both parents. Attempts to create and develop a rapport with both parents was attempted numerous times. Both parents were provided with resources as well as different options for them to be able to complete their services, even when they were in the midst of changing their locations, both in Amarillo and in Lubbock. We also created a tailored visitation plan and a flexible visitation plan in order for the mother, Jolie Simmons, to attend virtual visits with her parents, with her children, excuse me. And we also at one point attempted to bring the children back in region so that Jolie could have person-to-person visits with the children. That was ordered to not go through as Ms. Simmons had not been working any services and had continually failed drug screens. But we continued to try and reach out to the parents, both of them, even Mr. Williamson, who had not had any contact with the department, to try and provide him with his family plan of service, and continued to reach out to Ms. Simmons to help her along with her family plan of service, to which she has had no contact with the department.
Now, going back to the visitation, do you have the dates that Ms. Simmons, prior to her visitation being stopped at April of 2025, do you have the dates that she missed visits?
And the dates that she missed visits would be, so she had missed her visit on the 15th of April. She had cut out short on a visit on April 1st. And she had missed a visit on March 18th.
Thank you. Do you believe it's in the children's best interest that Jolie Simmons' parental rights be terminated to them?
Yes.
Can you please state in detail why?
Throughout the course of the case, Ms. Simmons has not made any valid attempts to work any of her services, even when she's been provided different resources, different options. We've been flexible with her with trying to find her different providers, find different ways and means for her to attempt and work her services, to where if she couldn't get to a service in person, we looked at options for her to be able to do them online or virtually. We looked at different providers for her when she moved and changed locations. Throughout the course of the case, she has continually tested positive for illegal substances. She was offered resources to help her mitigate that situation, not just being sent for drug screens, but also offered resources to help her to try and work through those situations and whatever was causing her to rely on illegal substances. She was given opportunities and help with support as far as when she did initially relocate, with help with furnishings and items. As such, she was given vouchers, which she did not utilize to try and get furniture both for herself and to be able to provide for the children.
Okay. Would you also agree that exploring those virtual and online options for Jolie to complete her services was also a reasonable effort to reunify?
Yes.
And would you agree that helping her with furnishing and items that she provided vouchers for was also a reasonable effort to reunify?
Yes.
And to your knowledge, what city is she currently living in?
The last reported location she had given was Lubbock, Texas.
And has she given you an exact address?
No.
Now, in regards to not knowing where the mother lives, does that mean we can't determine if it's a safe environment?
That is correct.
We can't determine if the people in the home with her are safe as well.
That is correct.
And so if Jolie is living with anybody, we don't know their criminal history or their CPS history. Is that correct?
Yes.
As well, we don't know whether or not they're sober. Is that correct?
Yes.
Would you agree that those unknowns create a safety issue?
Yes, they do.
And for all of the reasons you've mentioned regarding best interest and reasonable efforts to reunify, do you believe that the department should be named permanent managing conservator for the children?
Yes.
And is that in their best interest as well?
Yes, it is.
What are the department's plans for Desmond and Hope?
The plans for the children are to seek unrelated adoption. They are already in a home that is adoption motivated. They are bonded and, needless to say, connected with the family that they are living with right now. All of their needs are being met. So at this point, there would be no reason to seek out any other resource other than to leave them in the home where they're at.
And has the current placement expressed a desire to adopt both children?
Yes, they have.
And would that be in their best interest as well to continue in that home?
Yes, it would.
Do you believe that Jolie has the parental skills to provide the children with a safe, healthy, clean environment?
No, she does not.
Do you believe that Damien can provide the children with a safe and clean environment?
No, he cannot.
Do you believe that either parent can provide for the emotional well-being of the children?
No, they cannot.
Do you believe that the parents can provide for the physical needs of the children?
No, they cannot.
Let's see here. And throughout the case, has Damien been in communication off and on with the St. Francis workers?
No, he has not.
Okay. Did Ms. Simmons ever identify any other potential father other than Damien Williamson?
No, she did not.
are we asking the court to terminate Damian Williamson's parental rights as an alleged, I'm sorry. Okay, are we asking the,
We had some interference, so if you'd start your question again.
yes, Your Honor. Juan, are we asking the court to terminate Damian Williamson's parental rights based on the alleged father statute?
Yes.
Your Honor, we ask that the court take judicial notice of the certificate of paternity registry searches for both children filed on January 31st of 2025.
All right, so noted.
Thank you, Your Honor. And I pass the witness.
All right, thank you. Ms. Grant, questions?
I'm sorry, Judge, can you hear me?
I can.
Okay, thank you. I just wanted to ask a couple of questions, Mr. Heredia. To what extent do you believe that Jolie's mental health prevents her from participating meaningful in any services?
Due to the fact that she hasn't had any assessments, I wouldn't be able to gauge that.
Do you feel it was significant enough, however, that that assessment was necessary in order for her to proceed?
Proceed as far as?
Yeah, Your Honor, she may be frozen at the moment.
I think so.
I'm sorry, sir. I believe that my computer froze. Did you say yes or no to that question?
I asked proceed as far as what?
Continuing with the service plan as designed.
Yes.
Okay. And during the course of the case, did Ms. Simmons ever provide a clean drug screen?
No.
And
she provided a clean UA, but not a hair follicle.
Thank you. And the drug screens that were missed were presumed positive, am I correct?
Yes.
And when is the last time you had meaningful contact with Ms. Simmons?
The last time I had meaningful contact with her was on, give me just a moment, was on May 29th during a phone call. That's when afterwards, previously she had reported that she had moved to Lubbock. But when I talked to her that day, she would not disclose her exact location so we could meet.
And have you made attempts since that time to contact that same number?
Yes, I have.
And what result has that given you?
The result I get is that if I send a text, the message sent failure or not delivered, and the phone will play an automated message stating that the service, that the person who has the phone has basically no service. Other than that, I have sent her emails, and she had responded to emails that she would not test for the department until she was assigned a worker in Lubbock. This was in June. And then in July, she responded to an email that she would not do a hair follicle, to which she did neither a hair follicle nor a UA screen.
Thank you. And has she responded to any emails since that one that you just stated?
No.
Have you sent or attempted emails or phone calls?
I have not emailed her in August. And when I have called in August, there has still been no answer.
Okay. And it is your belief that that phone number is disconnected. Is that true?
Either disconnected. I know she did used to use like a pay service for the phone. It wasn't like a regular phone, but she used to sometimes run out of minutes.
Okay. And if I represented to you that the results that my office has received are the same, would you have any reason to disagree with me?
No.
And have you stayed in touch with my office regarding this case, just in case Jolie does materialize again?
Yes, I had emailed you all in regards to what she had sent me over.
Okay. And do you have any reason to believe that Jolie is incarcerated or in custody in any location at this time?
I don't at this time.
Have you made any attempts to check custody records to investigate that possibility?
I had not, ma'am.
Okay. If I represented to you that I am unable to locate her incarcerated in any location, would you have any reason to disagree with me?
No, ma'am.
And she has not been incarcerated to your knowledge through the course of this case. Is that true?
That is correct.
And is the same true for the father?
That is correct.
Okay. Pass the witness, Your Honor.
Thank you, Mr. Hill.
No questions, Judge.
Ms. Wiggins.
Just a few. Juan, you indicated that part of the service plan was for mom's mental health. Is that correct?
Yes.
But she didn't have a mental health concern, or did you have any concerns with her about her understanding while you were communicating with her?
No, ma'am.
Okay, so she wasn't so mentally deficient that you couldn't have a meaningful conversation with her.
No, she could communicate, openly and without hesitation.
Okay, and she seemed to understand everything that was requested of her.
Yes.
You just felt that the mental health assessment would help her potentially become a better parent and create a safe environment for the kids.
Yes, and then also that plan was created by a previous worker, depending on the context that they'd had previously, and potentially because of the type of situation that the children had been removed from, just to make sure that they were operating in a coherent manner.
Okay, so you wanted to rule out or include any mental health issues that could have caused the hoarding behavior.
Yes, ma'am.
I'll pass the witness, Judge.
Okay. Anyone have further questions for Mr. Heredia?
No, Your Honor.
All right. Juan, did Ms. Simmons, I don't have her service plan right in front of me. Did her service plan, like most of them, include saying that she's to abstain from use of illegal substances?
Yes, Your Honor.
And is marijuana an illegal substance in the state of Texas?
Yes, Your Honor.
Okay. Now, these children have been in the custody of the department for more than 6 months, correct?
Yes, Your Honor.
And was the service plan that you went over in detail concerning Ms. Simmons, was that a reasonable effort on the part of the department to reunify the children with her?
Yes, Your Honor.
Had she worked those services, could the children have been reunified with her?
Potentially, yes, Your Honor.
All right. And you testified she was missing some of her visits or leaving early even before they were suspended. And then they were suspended because of her own actions, because of the drug test, correct?
Yes, Your Honor.
So would you say that she has not regularly visited or maintained significant contact with her children?
That is correct.
And so would you say that all that taken together, that she's demonstrated an inability to provide the children with a safe environment?
Yes, Your Honor.
Okay. All right. Thank you. All right. Ms. Gutierrez, do you have any other witnesses?
No other witnesses, Your Honor. We ask that the court grant findings that the department has made reasonable efforts to reunify as detailed in all of Mr. Heredia's testimony.
All right, I will make those findings. Okay, Ms. Grant, did you have any witnesses?
I have no witnesses, Your Honor, and for the record, I would make a motion to continue this hearing from this point to allow me to further research for Ms. Simmons and attempt to have her present for the hearing.
All right, I will deny that motion.
Thank you, Judge. I'll rest.
Thank you, Mr. Hill. Any witnesses?
No, sir. Rest.
All right, Ms. Wiggins, any witnesses?
No, Your Honor.
Ms. Wiggins, recommendations.
Thank you, Judge. I do believe it's in the children's best interest that the parental rights of the mother be terminated. Also, the parental rights of the alleged father and any unknown father. They're in a very loving, stable home, and I do believe it's in their best interest that they remain in there.
Okay, thank you. Okay, then based on the evidence I've heard today, as well as the exhibits that have been admitted, I do find that it's in the best interest of the children that the parental rights of the mother, Jolie Simmons, be terminated. I'll terminate those rights today based on Texas Family Code Section 161.001, subsections B, 1, N as in Nancy, and O. I further find that it's in the best interest of the two children, the parental rights of Damian Williamson, if in fact he is the biological father, or any unknown fathers be terminated. I'll terminate those rights based on Texas Family Code Section 161.002B, as in boy. I'll name the department permanent managing conservator. I'll continue the children's current placements. I will continue Ms. Wiggins with the Randall County Domestic Relations Office in this case. All other court-appointed relationships will be dismissed after all appellate and de novo periods have expired. Ms. Grant, Mr. Hill, if you do talk to your clients, inform them of their appellate and de novo rights. I will set the first placement review hearing in this case for November 10th, 2025. That will be by Zoom like today's hearing, so the parties that are still involved in the case at that time can go on the court's online docket a day or two before Wildman is with us
for
for
the
the
department.
department.
Ms. Wiggins is with us representing the children. Mr. Sain is with us representing the mother, Ms. Furr, who is with us. Mr. Ronho is with us representing the father, Mr. Cross, who's not with us, and as far as I know, I show he's still incarcerated. Is that correct, Mr. Ronho? Yeah, okay. All right. I have Erin Tyndall in the waiting room.
That'd be my worker, Judge.
Okay, we'll get her in.
And is it fair to say that we've got some really positive updates regarding Mom and her service plan today?
We do indeed.
Perfect. So let's start off real quick. How are the children doing in their current placement?
Children are doing wonderful in their current placement. They're healthy, happy, doing great.
Are there any medical needs or updates or anything that we need to talk to the court about today?
No, they don't have any needs.
All right, and so tell us what sort of updates we have on Miss Furr's family plan of service.
So Ms. Furr has completed all of her services as of like last week. She was done with absolutely everything. She has turned in all of her certifications for all of her services as well. She has her own home. She has continued employment. I've been to the home to assess it for the safety and appropriateness of the children. We have also increased visitation with Ms. Furr starting last week, and have a reunification plan that continuously increases that visitation until reunification starts with her and the children.
And I believe you filed that reunification plan with the court, correct?
Yes, I did.
And is it at this hearing your recommendation that the children continue with that step up on that reunification plan at this time?
Yes, it is.
Do we have a projected date on when we would like to see the children back in Ms. Furr's home, as long as everything goes well?
As long as everything goes well, placement to start reunification will start on June 2nd.
Okay. Now, as far as the father in this case, has he made any progress in his services?
So Mr. Cross has been incarcerated the majority of the time of the case. He was in Swisher County and was not able to do much. He is now in Potter County. He has reported to me that he took some anger management classes, but I have not seen any kind of certification for those. He still comes and talks with me and I visit him in the jail, but we have not had much progress on his actual plan of service due to being incarcerated.
Now, are we certain that as of today, he's still in the Potter County Jail?
I have not had any updates, but as of just a few weeks ago, he was still in Potter County.
All right. And then, so at this point, I mean, what is the continued danger in trying to return the children back to his home?
So Dustin has not obviously completed any services. He is still incarcerated. He does not know a release date. I don't have that information as far as a release date for his criminal charges. So that would be the continuing danger.
Okay, but at this point, I mean, is there a continuing danger in the sense of returning them to Miss Furr's home at this point until she can show that she can, I guess, have the children with her on this reunification plan?
Yes. So, I mean, I wouldn't say it's so much a continuing danger as we are trying to slowly transition the children back into her home, not because she is a danger to them, but to help them reintegrate in with her routine and her to get used to their routine and just that change. So we try to do that slowly so that we don't cause any more trauma to the children.
Yeah. And Miss Furr is in agreement with that plan?
Yes, she is.
And she's ready for this step up to begin?
She is. She did great last week with her first 2 days of the step up. And then today will be her third day of the step up. So I'm gonna say so far, everybody has reported really good things.
Okay, perfect. Now, do you believe the department's making reasonable efforts to reunify the children with Miss Furr?
I do.
Do you believe they're trying to make reasonable efforts to return them to Mr. Cross?
I do.
What are the recommendations at this point?
Recommending that we leave the children in their placement, that we continue on with this step up in visitation and working towards reunification.
Are there any additional services that needed to be added to the service plan by court order today for either parent or the children?
Not at this time.
I'll pass the witness, Judge.
All right, thank you. Mr. Saint?
Thank you, Judge. Hello, Ms. Tyndall. I want to thank you for working with Ms. Furr. Clearly, y'all have had a good working relationship, and this case has been very successful. But I have to ask, so you don't believe there's a continuing danger regarding Ms. Furr at this time?
No, once we start the reunification process, it's not so much that there's a continuing danger in her home. It's more that we like to try to make this process of the children going home easier on them, because it is a change in routine, a change in atmosphere, a change in home, a change in beds. So we try to step this up in a slow, safe manner so that the children have time to get used to these things. But there isn't so much a danger with Mrs. Furr at this point.
And I'm sorry, remind me, how old are the children?
Avery is almost 2 and Natalie is not quite 1.
Okay.
I may have that backwards. I'm sorry. Natalie is the older one.
I don't, have you seen cases, 'cause I know I have, where sometimes the back and forth can actually be difficult for a child when you're doing this?
In cases of children where they have been with foster parents and have bonded with foster parents in a big way, depending on like that time frame, that can cause some issues. Most of the time, though, the slower the transition, not so much slower, but the easier the transition as we ease them into it, it gets them used to the different, like I said, the different routines, the different atmospheres, instead of just picking them up out of one and putting them right into another. It also allows Miss Fur time to get herself used to that new routine, getting up with the children, feeding kids, and understanding what she's realistically going to look at needing, as far as food and diapers and all of that. So it gives her a little bit of time to prepare for all of that, as well as the children to get used to that new routine and those transitions and changes.
Okay. Assuming that we're not going to be back before June 2nd, would you be opposed to the court allowing the advocates to speed up the process if things are going well and if it looks like it is causing problems for the children going back and forth?
If the court feels the need to intervene, if it is causing issues with the child or the children, it is always our priority that their well-being be put first. So I wouldn't be opposed to that if there was issues.
And you feel the advocates, the attorney ad litem, the guardian ad litem, are good people to make that judgment?
Absolutely.
Okay, thank you. I appreciate it. Thank you. I'll pass the witness, Judge.
All right. Ms. Naranjo?
Ms. Tyndall, are you aware that Mr. Cross has pled guilty to his felony and is now sentenced to 3 years at TCJ?
I was not aware of that. Last time I talked with him, he did not have any information that he was willing to give to me on his criminal.
I'll pass the witness.
All right. Anyone else have further questions for Ms. Tyndall? All right, then. Mr. Wildman, anything further from the department?
No, you're not from the department.
All right, then. Mr. Saint, anything further?
Yes, I'll call my client, Ms. Fur.
All right, Ms. Fur, if you'd unmute, please. Mr. Saint.
Thank you, Your Honor. Ms. Fur, first of all, I want to congratulate you. Everybody in this media or this hearing will tell you that not all parents achieve what you've achieved and work as hard as you did. You understand the step-up plan that the department is recommending?
Yes.
Have you seen it?
Yes.
Okay. Do you feel good about it?
Yes.
Okay. Are you in agreement with that?
Yes.
Okay. Is there anything about the process or the step-up plan or anything that you don't understand or have questions about?
No.
Okay. And you have Ms. Tyndall's contact information, correct?
Yes.
Okay. So have you had good communication with her?
Yes.
Okay. Great. Thank you. I'll pass the witness.
All right. Ms. Wildman, any questions for her?
No, Your Honor.
Ms. Naranjo?
No, Your Honor.
Ms. Wiggins?
No questions.
All right. Anything further? Any other witnesses, Mr. Saint?
No, Your Honor. That's all I have. I rest.
Thank you. Mr. Naranjo, any witnesses?
No witnesses, Your Honor.
All right. Ms. Wiggins, recommendations?
I recommend that the children's placement be continued. I'm obviously in agreement to the reunification plan and look forward to the kiddos being reunified with mom. I do agree to the plan. I do agree with Ms. Tyndall that it is better to do a step up, especially kids these young age.
Okay. All right, then. Based on what I've heard, then I will continue the department's temporary managing conservator. I'll order a transition monitored return of the kids to Ms. Fur, according to the current reunification plan that was testified to. I'm going to move up our next review hearing. It was going to be set for August 18th. It looks to me like things are going to go well. And if the kids are reunified by June 1st, I'm going to go ahead and move up. I just happen to have this date handy, so I'm going to use it. I'm going to move up the next permanency hearing to June 23rd, 2025. It will be by Zoom, just like today's hearing, so parties and attorneys can go on the court's online docket a day or two before June 23rd to see what time that will take place. I will note that if everything goes well and the kids are back home and everyone agrees it's time to dismiss the case, I'll be happy to sign an agreed order dismissing the case without waiting until June 23rd to do so. If not, then we'll see y'all back on June 23rd. Otherwise, we'll stand in recess. Everybody have a good week. And Ms. Fur, congratulations. What's been testified to is correct. It's very unusual to have a parent complete everything at the initial permanency hearing. Usually we're just trying to get them to get started. So congratulations, and I commend you for that. All right, we'll stand in recess until 1:45. Y'all have a good week.
Thank you, Your Honor.
Mr. Saint and I look like we're together, but I promise we're not.
Yeah. Y'all must have had the same builder.
We did.
All right.
Side by side, because you can see we're mirrored opposites.
I am waiting for Ms. Gutierrez to join us.
I'm
there
here,
she is.
Your Honor.
Okay. All right. This is a motion for leave to intervene, as well as some basically motions to strike filed by some of the parties. Ms. Gutierrez is with us for the department. Ms. Wiggins is with us representing the children. Mr. Saint is with us representing the father, Mr. Hewitt, who is not with us, not in the waiting room. Ms. Grant is with us representing the intervenors that are, I show Sherry and James Foster. I have an Ashley Foster in the waiting room. Could that be one of the potential?
Ashley Foster is a witness, Your Honor.
Okay.
Mr. and Miss Foster have texted that they can't get in, so we're resending the link to see if they have a problem with their link, maybe.
Okay. We're also waiting on Mr. Michelson, who has filed an objection or a motion to strike. He represents the mother, Miss Hewitt. He's not in the waiting room either, so we'll give it just a little bit more time before we get started.
And Judge, he had indicated that he might appear by brief, and I did see that he filed a brief.
Okay, I've seen his brief.
And Your Honor, Mr. Hewitt will not be here. He was starting a new job today and couldn't take off.
All right.
And Your Honor, I've sent our petition, which is our brief, to Brittany to provide to the court because I couldn't see where Randall County had put it in the record yet.
Okay. I don't know that I have that, but.
I just now emailed it over to you, so.
Okay. All right, there's Mr. Michelson. Okay, Mr. Michelson's now joined us. He represents some other Miss Hewitt who's with us, and they have filed a motion to strike the potential intervention too. I think I can kind of short circuit some of this when we get down to taking testimony. Mr. Michelson, I've read your brief and looked at your motion to strike. And the brief and the motions keep talking about that these potential interveners don't meet the requirements of section 102.003A9, which is
Your Honor, I am so sorry to interrupt. I just realized Stephanie Corbett, my worker, is not.
Oh, she's in the waiting room. Mr. Michelson, you're arguing that they don't meet the requirements under A9, person other than a foster parent who's had actual care for at least 6 months, et cetera. But that's not what they're trying to come in under. They're trying to come in under substantial past contact under 102.004B. So I don't want to hear a lot of evidence that they might not meet the requirements of A9 because I might be willing to agree with you there. But I'll only want to hear evidence of what substantial past contact these potential interveners have had with these children. So that might short circuit some of the testimony. Then I'll let anybody make their legal arguments if they want to when we've heard the testimony. So, all right, Ms. Grant, we'll give it a few more minutes to see if your clients come in. I'll be back very shortly.
Thank you, Judge. Okay, that first one, Judge, are Jim and Sherry Foster.
Okay. And the second one is your witness, you said?
Yes, Your Honor.
So Ashley Foster is actually your witness.
Correct. That I may not need, Judge, in the interest of time. We have boiled our case down to a timeline that we hope the court will find organized and able to lay out our points briefly.
Okay. Is that in your brief or what? Or
no, I didn't put it in my brief because
okay.
I need testimony on some of it,
right.
Judge.
All right. So who is it you want to call as your witness?
I want to call Sherry Foster, Your Honor.
All right. Ms. Foster, if you
Your Honor, I'm sorry. If I could, I'm sorry to interrupt, Judge, and I hate to say this because my client's opposed, but I do know that the courts have said a grandparent does not need to show substantial past conduct. That phrase does not apply to the grandparents.
Well, I'm just going by what they pled, but I agree with you wholeheartedly. That's why I was kind of trying to guide the testimony because I don't think we're going to need to hear a lot of testimony.
I think mostly, Judge, we're going to give a brief timeline in line with what Mr. Saint is saying, and then we are going to make our argument for impairment that makes it reasonable for intervention.
All right.
And Judge, my client is opposed, but not on that point.
Okay. All right. Ms. Foster, if you'd raise your right hand, do you swear the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Thank you. You may proceed.
Ms. Foster, how are you related to the children, the subject of this case?
I am their grandmother.
Okay, and I know this is upsetting for you, but try to, stay calm so that we can kind of be sure that the judge can understand your testimony, okay?
Okay.
Okay, from September 15th to April of 2022, did Levi, the oldest child, and the mother reside with you in Lindsborg?
Yes.
And then after Callie was born, did she move in 2018 and reside with you and the mother till 2020?
Yes.
And then at many points in their lives, have the children resided in Kansas and you've seen them regularly?
Yes.
Did there come a time when there was a previous CPS case regarding these children?
Yes.
Were you the placement for these children during that CPS case?
Yes, we were.
Are the reasons for removal in this case the same to your understanding as the reasons for removal in the previous case?
Yes.
Is it
Plus
drugs?
other things.
Okay.
The
Are
first one was
drugs
not drug related.
Right, y'all are talking over each other. Ask
Sorry.
the question and let her finish the question before you give an answer, Ms. Foster.
Are drugs an issue for your daughter?
Not that we were aware of, but
When
of
did you
her.
become aware?
We became aware after she moved to Texas.
Okay. And so with the previous removal in the case and the current removal, do you have a concern that these children will continue to be in and out of the foster system?
Yes.
Are you willing to be placement for these children should the court deem it appropriate in a later finding of the court?
Yes.
And are you asking the court today for permission to intervene in this case as the maternal grandparents based on your role there as having past contact with them and being their maternal grandparents?
Yes.
And in the petition to in our petition to intervene, is it correct that we have alleged that the parents are at risk of continuing to cause future impairment to the health and safety of these children?
Yes.
And is part of that impairment the fact that Aaron Hewitt has continued to test drug positive for this case since it has been conceived?
Yes.
And Your Honor, I would just ask the court to take judicial notice of the case quoted in my brief where courts have found that drug use by parents is a reason for intervention by grandparents when the court deems necessary.
All right, I haven't seen it yet, but I'll look at it as soon as I get it.
Thank you, Judge.
Brittany, if you don't mind, excuse me, Brittany, if you don't mind, if you receive that, would you print it and bring it to me in the courtroom?
Yes, I will do that now.
Thank you. Go ahead.
And Judge, that case is Henry KDH out of Texas Appellate Court in Houston, where the courts found that significant impairment of the child's physical health and emotional development can be found with evidence of parental drug use and criminal convictions or incarceration. We would ask the court to take judicial notice of any drug screens that are filed in this case, specifically the drug screen for the father, Aaron Hewitt, in January of this year, which was cause for concern in this case, Your Honor.
All right, so noted.
And additionally, courts have found that for grandparents, significant past contact is not required. However, we would just briefly like to prove that they have had substantial past contact through the brief testimony I provided based on the previous CPS case and the Texas case.
Okay.
We are, the other concern that is raised, Your Honor, as far as impairment is, or let me continue my question. I apologize. I don't have a quote for that one.
Okay.
So Sherry, during the course of this case, are you aware that parents are required to provide transportation for their children?
Yes.
Do you assist the mother in providing transportation?
Yes, we do. We make the payment on the vehicle.
Okay, so the vehicle that she currently drives that gives her credit for having transportation for the children, you pay that payment, correct?
Yes, we do.
And that's because Jim is the co-signer on that note and you're trying to keep that note in good standing. Is that true?
Yes, ma'am.
Have you regularly been asked to provide gas money and other money for basic needs by the mother during the pendency of this current CPS case?
Yes, we have, and before.
Okay. Did you at some point decline to provide any further funds and tell her that she needed to be successful on her own?
Yes, I have.
Did that result in the fracture in your relationship that resulted in the filing of this intervention from you?
Yes.
Are you afraid that your grandchildren will not, or just tell me your fears for your grandchildren. Let's just do that. And you tell the judge what your fears are and why you're intervening.
We are fearful that they're going to go back. Sorry.
It's okay.
To what we heard from our grandchildren.
And you can't tell me anything you heard from children. Just
okay. Well, I'll qualify that. If they've heard things from the grandchildren that would amount to abuse, then it's not hearsay.
Okay. So we did hear from our grandchildren, all three of them, that they were being hit with a belt and they were being smoked in front of all the time. And just the ongoing verbal, mental, and physical abuse that we heard from those kids makes us very, very scared for them.
Are you concerned?
We can give them security here in our home and love that they need and structure. And we have done it before.
Okay. Do you have other relatives that live near your home who also have an interest in the success of these children?
Yes. Their uncle and aunt.
And what are their names, please?
Cody and Ashley Foster.
Okay.
My mother, Mary Lou Jean. Go ahead, sorry.
You're okay. That was my fault. Do you have concerns that the parents are not being forthcoming with CPS in this case?
Yes, I do.
And do you believe that your intervention is necessary to protect these children should they not be reunited with the parents?
Yes, we do.
And you're asking the judge to allow your petition to go forward today in an effort to be to get custody of these children, to keep them from remaining in foster care. Is that correct?
That is correct.
Okay. Pass the witness, Judge.
All right. Thank you. Mr. Michelson.
No questions for this witness, Your Honor.
All right. Mr. Saint.
Thank you, Your Honor. Yes. Ma'am, are you aware that the, excuse me, that the March and April drug tests for the parents were negative?
Objection, Your Honor. Assumes facts, not in evidence.
No, we've already started talking about drug tests, so I'm going to overrule that. Somebody open the door on that.
And Your Honor, in case Ms. Grant was specific, she did ask you to take notice of at least one drug test. I'd ask you to take judicial notice of all the drug tests,
So
including
noted.
in April.
Fair enough.
Were you aware of that, Ms. Foster?
I have seen those on the county records.
Okay. And regardless of whether they get clean and stay clean, you don't want the children returned to them?
No, because they've already been taken. This is the second time, and I know there will be a third.
Okay. So, in your opinion, there's no more chances, and no matter what they do, the children shouldn't go back to them?
This is correct.
Okay. Thank you. I'll pass the witness.
All right. Ms. Wiggins.
I have no questions.
All right. All right. Then, Ms. Grant, did you have any other witnesses regarding your case?
No, Your Honor. We'll just we'll stand on our brief that has been provided to the court through our petition.
Do you have a separate brief? I'm looking at petition and intervention, but is that brief included in it?
Yes, Judge. I just included my argument within my petition.
Okay.
The court did grant our motion to leave, Judge, on February 22nd. Right. So I think we've disposed of that portion of this case.
Yeah, I think you're right. So
we're just on motion to strike.
Yeah. Okay. All right, then. If you don't have anything other than Mr. Michelson, do you have any witnesses just as to the motion to strike?
No witnesses, Your Honor. Just a brief argument.
All right. Mr. Sain, any witnesses?
No, Your Honor. I do have argument as well.
All right. Ms. Wiggins.
I have no witnesses, Judge.
All right.
I don't know if you asked Ms. Gutierrez.
Oh, yeah, I did. Ms. Gutierrez, do you have any questions or any questions of anybody or any witnesses?
No, Your Honor.
All right, then. We'll just start at the top. Mr. Michelson, you wanted to make a brief argument?
Yes. Even if interveners have demonstrated past substantial contact, before the court allows them to intervene, it has to show that intervention will not complicate the case. And by the presumable request, the permanent managing conservator, they'll ultimately be asking for permanent managing conservatorship, which causes complication to my respondents. And also it conflicts with the primary goals and termination cases as to the reunification of families. And as to the rest of the argument, I would just stand on my brief.
Okay. Well, just a brief response to that. This court's opinion is, and it looks like we're headed that way, if there's any potential that these parents may be terminated, to have some other relatives willing to stand up and adopt, it doesn't complicate the case for me at all. It makes my job easier. So that's probably didn't need to say that, but I said it anyways. All right, then, Mr. Saint, you had an argument?
Yes, Judge. First of all, I would point out to the court that the interveners must impress the court to intervene. Rule 60 requirement for an objection is inapplicable in SAPSR cases because 102 sets out requirements for standing. And in this case specifically, they have to ask the court for leave to intervene. They can't intervene until the court grants that, as Your Honor knows. I would ask that you not allow them to intervene. I think there's a due process concern, as Ms. Foster stated. They're here to undermine the statutorily required goal of the department to work with the parents to work towards reunification. And they're going to work against that, as Ms. Foster said, no matter what happens. They can still be considered for placement if they're appropriate by this court, whether they intervene or not. And in fact, CPS has a duty to look at them as placement if reunification cannot be achieved. Furthermore, it is not necessary for them to intervene because if there is termination, then they can file a suit afterwards to get custody. The only purpose to intervene is to undermine my client's ability to complete his services, get clean, and get his child back. And I understand and I certainly appreciate why the court feels that, generally speaking, a grandparent intervening does not unnecessarily complicate the case. I will, again, referring to the fact that it undermines my client's rights. I'll point to that it is going to add a lot to, I think, to the trial in that I'm going to have to be fighting not only with CPS to make sure CPS does their job, but even if CPS does their job and they're successful, we're still going to have to fight the parents to protect the constitutional rights of my client. Thank you.
All right. Let's see then. Ms. Grant, you didn't have an argument, did you? I mean,
just very briefly, Judge, in
Okay.
response.
All right.
Your Honor, we did properly, through the process, file a motion for leave to intervene. The court granted that on February 22nd, and that's in the record. Then we filed our petition. We did not file our petition until that motion was granted. And if the court recalls, parties in this case never objected to that motion for leave to intervene until we had a permanency hearing and they were reminded, and the court was gracious and gave them a little more time to object, but they did not even make timely objections when that was initially filed, Judge. Secondly, the Fosters do not seek to undermine the mother. In fact, they are financially supporting her by giving her cars and helping her with money when she texts and asks. And that testimony flies in the face of feeling like they would be undermining her. They wish and want that she could be successful, Your Honor, but this is the second go around in CPS. And I agree with my clients in that there just can't be a third for these children. At some point, the damage is irreversible when we keep cycling children through the CPS system.
All right. If anyone can clarify this for me, Ms. Grant, did I actually sign the motion allowing intervention?
You did, Judge. It's in the record.
Okay.
It was signed February 22nd.
Okay. And
Your Honor, I'm sorry. Maybe I thought you signed an order allowing her to file a petition in intervention, not to actually intervene.
I'll have to. I'm on the bench and I can't pull up but I'll look at it.
I'm sorry. You granted our motion for leave, Your Honor.
Here's what my notes reflect from a hearing on February 3rd, the initial permanency hearing. I ruled that if there's no motions to strike filed by any of the parties by February 20th, 2025, the motion for leave to intervene on behalf of the Fosters will be granted. So my only question is, did I sign the order? Because if I'm not, that needs to be part of this order today. So.
Yes, you did, Judge. You checkmarked granted and signed it on February 22nd.
Okay. I'll pull that up to verify that. But okay. Ms. Wiggins, did you have any argument or are you ready for your recommendation?
Judge, I just want to clarify the issues. Is this just for intervention? They're not asking for placement and they're not asking for contact. It's just an intervention.
That's correct, Judge.
Yeah, I don't have any pleadings asking to change placement at this point.
Okay. Then I have no argument in regards to the intervention.
Okay. No, you're not
I don't
in opposition, or you just don't have an opinion.
I just don't have an opinion.
Okay.
Just leave it at that.
Okay.
Your Honor, may I have an opportunity as well?
Yeah, sure.
Thank you, Your Honor. I did want to bring up that there's actually a split in the Court of Appeals on whether or not substantial past contact is required for grandparents when intervening. I do think that these grandparents do have substantial past contact. At the last permanency hearing, I think it was February 3rd, the court did find that there was a continuing danger and could not return the children to their home. So we have no objection to this intervention, Your Honor.
Thank you for that. And that's a good point. I don't think it's necessarily settled completely that they don't have to have substantial past contact, but I've heard enough testimony today. First of all, I'm going to make a finding that the Fosters, Sherry and James Foster, have had substantial past contact with these children. I'm also going to find that there is a continuing danger based on what I've heard from the adversary on about these parents. So give me just a second here. So I do find there's satisfactory proof that the court that appointing a parent as a sole managing conservator or both parents as joint managing conservators would significantly impair the child's physical health or emotional development at this time. So based on what that is, I'm going to grant the motion to intervene if I haven't already signed it. And then I'm going to deny the motions to strike that are filed by Ms. Hewitt and Mr. Hewitt. So otherwise, previous orders will stand in effect. Our next hearing will be the permanency hearing set for June 2nd, 2025. That will be by Zoom like today's hearing, so all parties and attorneys can go on the court's online docket a day or two in advance of June 2nd to see exactly what time we'll have that hearing. So obviously the department will continue as temporary managing conservator, and as of today, the children's current placements will continue. So all right, that will conclude this hearing. I will be back at 2:30 to call another Randall County case. Ms. Gutierrez is with us from the department. Ms. Wiggins is with us representing the children. Ms. Rudd is with us covering for Mr. Barfield, representing the mother, Ms. Ledbetter, who is with us. And that's all the parties. I have Sylvia Garcia in the waiting room.
That's my worker, Your Honor.
All right, thank you. Ms. Gutierrez?
Thank you, Your Honor. For my own records, I am keeping track of who's here and who's not. Is the mother in the hearing today?
I thought she was. I let her in one time, and she may have fallen off.
I see her
Yeah,
name.
she's down at the bottom. She's there. She's just muted and doesn't have her camera on.
Okay, great. Thank you, Your Honor. I'll make note of that.
Okay.
Did you file a court report on April 14th of 2025?
Yes, I did.
Your Honor, we ask that the court take judicial notice of that court report.
So noted, and I did read that report.
Thank you, Your Honor. Sylvia, can we get an update on how Eli is doing?
So Eli is doing pretty good in placement right now. He's had to do some adjustment because he finally was able to move from the emergency shelter to the cottage. So he had a transition period there that did take some adjusting, but he's doing a lot better now.
Okay, and can we get an update on how Alyssa is doing?
Alyssa's doing very well. She actually does very good in placement. They have really looked up to her as a leader. She cares about the other children in the home. And she's very hands-on and she's really good.
Okay. And are Alyssa and Eli placed in the same placement?
So they're in the same placement, just not in the same cottage.
And what is the arrangement so that they are able to have visits together?
So they do the sibling visit, family visit with their mom every Friday. And every other Thursday, they also do a sibling visit with their older brothers. And on campus, if they're able to, and at placement, if they're able to see each other or they're able to make those arrangements, they do make arrangements for the kids to see each other. It just kind of really depends on what they have going out throughout the day.
Okay, great. So the children have 2 older adult siblings, is that correct?
Yes, they do.
And it sounds like St. Francis is facilitating visitation between them as well, correct?
That's correct.
At the adversary hearing, a home study was ordered on Ben Ledbetter. Can I get an update on that home study?
So that home study was, what they didn't continue with it. He went ahead and did not complete the home study. He just didn't feel that right now was a good time to do the home study because he doesn't have the support that he needs so that he could meet those tasks with Alyssa and Eli when it comes to counseling, pick up and drop off for school.
Okay. Can I get an update on April Ledbetter as well?
So April, she does do her monthly face-to-face with me. We've had a couple times where we've had to reschedule, but we were able to complete them within the time period, the 30-day time period that we have. She does she does her assessments when we ask her to. She has drug screened. The only thing that we didn't have was the initial drug screen that was court ordered. She was not able to complete that because she had a shy bladder. So she did show up to the facility. She did attempt to complete the drug screenings, but she had a shy bladder, so they weren't able to complete it.
And did she provide a hair follicle sample as well?
Yes. So she did provide one, but we have not got the results back on that yet.
And since she was unable to comply with providing a urinalysis sample on March 18th, was she sent another day to complete that urinalysis drug screen?
Yes, she was.
Okay. How is her visitation with the children going?
So we've had a little bit of issues with just following the rules with the visitation, but I think from the beginning to where we're at right now, there has been definitely some adjustment, and everybody's kind of doing better now following the rules. But at the very beginning, we did have issues with extra family members coming to the visits, the case being discussed during visits. But ever since then, we've talked to April about it, and she's been able to redirect those visits. So whenever she's there with the kids, it's happening less.
Okay, that's good to know. Is she showing up on time for her visits?
Yes, she does.
That's great. Have you prepared a service plan for Miss Ledbetter?
Yes, I have.
And does that service plan aim to mitigate the reasons for removal?
Yes, they do.
Is it reasonably tailored to the issues from removal?
Yes, it is.
Okay, and can you briefly tell us what caused the removal?
So there was a safety plan in place, and the safety plan was broken, and April continued to test positive on the drug screens that CPI was requesting from her.
And was that on methamphetamine?
Yes, it was.
Can you please identify 2 or 3 services only that are unique to Ms. Ledbetter?
Yes, so we have signed her up for individual therapy and also for the OSAR evaluation. Those would both help and benefit to see just kind of the decision making that's happening, and then also her drug use to see if she needs to do outpatient, inpatient treatment, and where we can help her with that so she could be successful with completing this plan.
And the OSAR evaluation, is that a substance abuse assessment?
Yes, it is.
And is that necessary for the parent, for April, to have a recommendation of what type of drug treatment to get?
Yes, it is.
Thank you. Has April reviewed the service plan?
Yes, she has.
Has she signed the service plan?
Yes, she has.
And did she make any statements handwritten on that service plan as well?
Yes, she did.
Can you please tell us what that statement is?
I don't agree with the removal reason. I will contact my attorney wanting to still work services April Ledbetter for 8 of 2025.
Okay, thank you. Are we asking for any drug screens to be ordered today on Ms. Ledbetter?
No, we're not.
Okay, do we have any other requests for the court?
We would just request that if we could continue to follow the safety plan that I have typed up for Ms. Ledbetter so that we could be successful with the reunification.
And by safety plan, are you referring to the family plan of service?
I'm sorry, yes, the family plan of service.
Okay, great. Pass the witness.
Ms. Garcia, would it be a continuing danger to the physical health and safety of the children to be returned home today?
Yes, it would be.
Would it be contrary to the children's welfare to be returned home today?
Yes, it would be.
Okay, thank you. Ms. Rudd, questions?
April is trying to work her services and getting things started, isn't she?
Yes, she is.
And she's making progress.
So we're still kind of pending services. As far as her being able to be there whenever we request for her to be there, we've had a little bit of a difficulty. We've had some rescheduling with her more than once. But I mean, if we call her and we need something from her, we can most of the time get it done, but it will take some time and some rescheduling on her part.
I'll pass the witness.
All right. Ms. Wiggins?
No questions.
All right. Anything further from the department?
Not for this witness, Your Honor. We do briefly call Ms. Ledbetter.
Okay. Ms. Ledbetter, if you'd unmute and if you can, turn on your video.
Well, let me check in with Sylvia. Maybe I won't need to call her then since she's not answering.
Looks like she was about to unmute.
April, can you try to unmute again?
Okay, I think I got it.
Okay, we can hear you. That's
I'm trying to figure this out. I'm sorry.
Can
you hear me?
I can hear you. If you can't do the video, that's fine. There we go.
Hold on.
Okay, we've got
I
you
don't
on.
know how to flip it around. Okay. Okay,
There we go.
can you hear and see me?
Yeah, we can. Well, yeah. So don't touch anything. Everything looks fine right now. All right.
Okay,
Ms. Ledbetter, if you'd raise your right hand, you swear the testimony you give will be the truth, the whole truth, and nothing but the truth.
I do.
All right, Ms. Gutierrez.
Thank you, Your Honor. Ms. Ledbetter, since Mr. Ben Ledbetter declined the home study, have you provided anybody else to St. Francis Ministries as a possible home study?
Yes, I wanted to check about Joanne Adams.
And what is her relation to you?
She is my my first mother, my ex-mother-in-law. She is the two older siblings. She is their nana.
And who else lives in her home?
No one right now. It's just her.
Oh, can you go ahead? Is it Joanne, Joanne, or can you spell her name?
J-O and then with a capital A-N-N.
Pass the witness.
All right. Ms. Ledbetter, have you given contact information for Miss Adams to St. Francis or the department?
Yes, I have.
Okay. All right. All right. Thank you. Ms. Rudd, do you have questions?
No.
All right. Ms. Wiggins.
No, Your Honor.
All right. Ms. Gutierrez, anything further from the department?
Yes, Your Honor. I recall Sylvia Garcia.
All right. Ms. Garcia, you're still under oath, so go ahead.
Thank you, Your Honor. Sylvia, really quickly, does the department have any objection to a home study on Joanne Adams?
So we don't have enough information on her for me to say that. I know that CPI looked into her, and I would have to look on the notes to see what exactly what was the concerns with.
Okay, but at this time, we're not objecting to a home study on her. Is that correct?
That's correct.
Okay, pass the witness.
All right. Anyone else?
No, Your Honor.
All right. Ms. Gutierrez, that all from the department?
Yes, Your Honor, that's all. The department rests. We just ask that those family plans of service be made in order of the court.
Okay. All right. All right, then, Ms. Rudd, any witnesses?
No, Your Honor.
Ms. Wiggins, any witnesses?
I have no witnesses.
All right, Ms. Wiggins, recommendations?
Department of Maine temporary managing conservator, both children. Both children are placed at High Plains. They're doing well. They are in cottages next to each other. So I know when I was visiting Eli, he saw his sister outside, and so they're trying to have more time together. I know that's an issue. They're very close, but they seem to both be doing very well. Eli has asked a lot of questions, so I can understand him trying to talk about the case and his visitation. But I think hopefully he understands. We just want him to be a kid. So that's what we're trying to get him to focus on.
Great.
And Your
Okay.
Honor, I apologize. We actually do have a request since Ms. Ledbetter didn't comply with the hair follicle order from the adversary hearing. Oh, wait, I'm
It is.
confused.
It's pending.
Your Honor, if I may recall Sylvia, she sent me a request
did
by
comply.
message.
All right, Ms. Garcia, if you'd unmute again. Go ahead.
So, due to Care Express not giving us a clear indication of it, they told me that it was pending, but our system shows that it's not. So, can we just be able to be given more time to make sure that it was completed? Because I know April did tell me that she did complete it, and Care Express is saying complete it, but we don't even show that it's currently pending. So, I just want to make sure that I get enough time to be able to speak to a supervisor at Care Express to see exactly what happened.
Well, I'm not sure what you're asking me for.
Yes.
If she's done it, it's not a matter of me ordering it be done any faster. If she's done it, she has. If she I can order that if it's not found or or she hasn't completed it, then I can order her to do it again upon request.
If we can, please.
Okay. All right. Okay.
And Your Honor, if I may clarify that request and go ahead and ask for her to be ordered to hair follicle today.
Well, it won't be today. We're too late.
Oh, you're right. We're right at 4 o'clock, Your Honor. I'm sorry about that.
I can order it again, but usually the department whines about having to pay for an extra one if it hadn't been.
I understand, Your Honor. I had received information earlier that she did not comply with that hair follicle, and now Ms. Garcia has said she's not seeing it even as pending in her system. So I think it would be best to just go ahead and order it, Your Honor.
Okay. Do you want another UA while we're at it?
Yes.
Okay. Okay, then. I will continue. Yes.
Yeah, I'm sorry. I know everyone saw it. April just messaged that she does have paperwork to prove that she did it. So
well, I'm not saying she didn't, but if they've lost it, then we're going to have to get another one because we need the baseline.
Okay.
Okay. If it's located between now and tomorrow at 4 p.m., then obviously there's no need for her to go, but okay. All right. I will continue the department's temporary managing conservator, continue the children's current placements. I'll order the services for Ms. Ledbetter as contained in her service plan. I'll order a home study on Joanne Adams, and I'll order that Ms. Ledbetter both hair strand and UA drug screen by 4 p.m. tomorrow if the results of her previous hair strand can't be located. Obviously, if it is located, there'd be no need for her to go. All right, Ms. Ledbetter, if you'd unmute again, please. Can you hear me?
Yes.
Okay.
Yes. Can you hear me?
Yes, I can. Ms. Ledbetter, I need to admonish you today that the services that are contained in the service plan that you signed, that becomes a court order today. At a final hearing, if you haven't worked those services, your parental rights could be altered or terminated. Do you understand that?
Yes.
Okay. All right. Thank you.
I have a question, Your Honor.
Uh-huh.
Can I actually, so when this all started, my 19-year-old son, Easton, can I request for him to be viewed before Joanne?
I'll tell you.
Eli was currently living with him when all of this started, and CPS had okayed it.
Well, yeah, Ms. Ledbetter, I can tell you, I'm not going to do that because I can tell you a home study for a 19-year-old to be the placement, it's not going to pass. And I probably I probably wouldn't order it even if it was, because I was a 19-year-old boy one time too. So,
yes, sir.
Okay. You want to stick with Joanne Adams?
Yes, sir.
Okay. All right. I've already ordered that, so we're good there. So.
Thank you.
Okay. All right. Our next hearing will be the initial permanency hearing on August 18th, 2025. That will be by Zoom like today's hearing, so parties and attorneys can go on the court's online docket a day or two before August 18th to see exactly what time that hearing will take place. Okay, we'll be in recess on this case. I'll be back here in just a few minutes to call two related final hearings. First afternoon, everybody.
Afternoon, Judge.
I will call two Randall County related cases, both on final hearings. I understand motions, well, not motions, but I understand the department wants to extend both cases, but I will call first. In that case, Ms. Wildman is with us, representing the department. Ms. Garrett's with us representing CASA. Ms. McDaniel is with us representing the child. Miss Riley's with us representing the mother. I don't see the mother, Miss Pelt, with us. Miss Riley, were you expecting her?
I was, Your Honor, and I'm not sure why she's not here, but I do have my office attempting to reach out to her to see where she is.
Okay, thank you. Mr. Michelson is with us representing the father in that case, the adjudicated father, Mr. Knowles. He's not with us either. Mr. Michelson, were you expecting him?
I was, Your Honor, and I sent him a link prior to the hearing, so.
Okay, we'll see if they show up. All right, I will also call related case number. Again, Ms. Wildman for the department, Ms. Garrett for CASA, Ms. McDaniel for the child. Mr. Turman is with us representing the father, Mr. Stewart, who is with us. And again, Ms. Riley's with us representing Ms. Pelt. She's not with us just yet. While we're waiting, in both cases, the department has, in their report, has requested to extend the cases and retain the cases on the court's docket. Let's just start. I've read the reports. I understand their rationale. Does anybody object to extending these cases?
I have no objection, Judge.
No objection.
No objection.
No objection, Your Honor.
Okay. All right. I've read the reports and I do find that there's extraordinary circumstances that warrant the extension. So I will, in both cases, order that the cases be extended and retained on the court's docket. So I'll be making my notes. We'll see if these other parties show up.
Your Honor, excuse me, if Allison Bratton is in the waiting room, she's the advocate on this case.
Okay. Yes. Yeah, she is, Janelle. I'll get her in.
Thank you.
And then Erica Cantrell would be my worker judge.
All right. We'll get her in. That clears out our waiting room. Okay. So we'll be treating today's hearing like any other perm hearing. So we don't need to treat it like it is, in fact, the final. I'll give it just a couple of minutes more to see if Miss Pelt and Mr. Knowles show up. Well, I still don't have anyone in my waiting room. Ms. Wildman, basically, since we've extended both cases, are we just basically asking for status quo today?
Yes, Your Honor, and I think we can do it pretty quickly. I think our court reporter also has a conflict coming up, so we can get through this as quickly as possible.
Okay, let's go ahead then. I've read the reports and it looks to me like we're just going to allow some more time for mother's situation to stabilize. So let's go ahead and proceed. I'll watch the waiting room.
And Judge, I would call Erica Cantrell.
Ms. Wildman?
All right, and Ms. Cantrell, getting a real quick update on the children. Let's start with Cora. Where is Cora currently placed?
Cora has been placed home with her father, Brandon Knowles.
And about how long has she been home with him?
She was placed home April 4th, so we are getting very close to a month.
Okay. And how has that reunification been going?
Been going very well.
How has Cora recovered from the eye surgery she had a couple months ago?
Cora looks absolutely amazing. There is a visible difference in her eyes.
Are there any other updates on Cora's medical that we need to address today?
No, Cora's doing very well.
Now, as far as the department is concerned and with Brandon's service plan, are there any other services that Brandon needs to complete at this time?
No, he has completed all services. He's meeting Cora's needs. We're pending some daycare for him. I've got that all submitted, but other than that, he's just really enjoying his time with her.
And has he been communicative and cooperative since she's been placed back home?
Oh yeah, absolutely. No problem with him.
And at this point, are we just asking to remain involved so that we can help support him and Cora?
Yes.
And whether it's now or in the near future, are we wanting to do mediation between the department, Brandon, and Miss Pelt?
That would be our hope, yes.
And so let's switch over real quick and get an update on Lily. Is Lily still placed in Oklahoma with her grandmother?
Yes, she is.
All right, and so go ahead and give us the update on what happened with Lily this month.
Yeah, so Lily was hospitalized in the psychiatric hospital. There was an incident at the after school program daycare that she was attending. She had some issues with a peer there. There was a argument. Lily threatened to get a knife and slit her throat. She was very upset with her, and then she proceeded during a session to tell her at the behavioral place that she goes the same thing. They did recommend that she be evaluated. She was evaluated there. The original intent, my understanding, was that she be there for a week, but her anger continued, and so she did end up staying for another week. So she was there a total of 2 weeks. There was some delay in telling me that, but I did let Seth and placement know, like, there is an immediate notification that has to be provided to me. They are very understanding of that. We're very apologetic about it. So we did that. I did let Diana know that, and all parties, once I did get that notification. But since that hospitalization, there were some medication adjustments. Mary and Seth both stated that they do see an improvement in her after that hospitalization. So there was some improvement in behaviors and with that medication change and such. So there was definitely a benefit of that hospitalization.
Now, just kind of to clarify, there's not necessarily anything wrong with the fact that they facilitated that hospitalization, but the delay in reporting was a concern.
The delay in reporting, yeah, definitely. I mean, they did what they were supposed to do. They followed all the recommendations. It was just the delay in reporting that we had to address with them.
Okay. Now, the medications that she had adjusted are the psychotropic medications?
Yes.
And obviously at the hospital, it sounds like those were adjusted and evaluated. Are those continuously being evaluated as needed?
Yes.
As required?
Yes, ma'am.
Okay.
Monthly.
And so, let's talk a little bit, get some updates on Seth real quick. So, what services are still needed for Seth to complete?
Seth doesn't have any services to complete. He's completed all of his services. We were able to finally get the completion of his psychosocial as well as his counseling services. So he has completed all services as well on his family plan.
Now, there was a home study that was requested to Oklahoma, correct?
Yes.
And was that home study initially denied?
It was initially denied, yes.
Have the concerns that were brought up in that home study, have you addressed them?
Very thoroughly with Seth and also with his attorney. And he did some additional trainings to address those concerns. Those have been completed as well.
And part of the concern was that there were concerns that he would be able to, I guess, seriously handle Lily's mental health needs.
Yes, that is correct.
After this most recent hospitalization, do you feel like he has the ability to do that and has shown that he has the ability to do that?
Yes, I do.
And so are we in the process of requesting another expedited home study for Seth?
Yes, we are.
And that was required by the court order last hearing that she not be placed with him or not be placed with him until that had passed?
I believe so, yes.
And so, at this point, are we still working towards placing with him?
Yes, we are.
Okay. Now, let's talk about Diana's progress. So, what, I guess, updates do we have on the progress she's made on her service plan since the last hearing?
She has completed that counseling. She definitely is easier to communicate with, but I do still continue to have issues as far as getting her financial status, her employment. She moved into her new place roughly, I don't believe we have right at 6 months. She did tell me that she does have employment outside of, the odd jobs that she had been doing, but I asked her, not at the last visit I supervised with her and Cora, to provide me with those, and she did not. I still don't have those, so I don't know exactly as far as employment what we have. So we still don't have 6 months of employment at this point as well either.
How is that visitation going with Cora?
She does great with Cora. We have had a difficult time as far as getting her regular visitation scheduled. We are very short-handed on supervision help, and so it's been up to me to get those visits going. I was out due to some health procedures that I had to have done, so I am trying to get her a visit this week of 2 hours scheduled for myself to supervise. So I'm working on that. But I mean, it's just been kind of a difficult time this month, especially.
And so has visitation with Lilly been able to start yet?
So that's another thing. Lilly has voiced that she is ready to see mom. She is very, very adamant that it be not in person. It is virtual. The issue I run into that is we have mom in Texas and Lilly in Oklahoma. And so the licensing to have that, we have that recommendation of therapeutic visit. So the licensing of a therapist being able to do therapeutic visits with Lilly in Oklahoma and mom in Texas has been a bit of an issue, but I believe I have located one. I've sent a referral over. And so we're just pending to see if that is going. Brandon just tried to attempt to call me and said he's in the waiting room. Just want to let you know that. Sorry.
He's not.
Okay. I'll let him know. Let me send him the link again. But I mean, that's the biggest problem we're in there and we're having is that Diana and she does they both miss each other. There's no doubt. But with that recommendation, my hands are kind of tied as far as what I can, as far as the visitation. But we are trying. I've emailed lots of our contractors and stuff, but that's the main issue is being in Texas and Oklahoma.
All right. And so is it accurate to say that she's been drug screening for us more consistently?
She is drug screening for us more consistently.
And that those have been negative?
They have, yes.
Do you, obviously it's 4:30 already, so are you requesting that she be ordered to drug screen, I guess by tomorrow, by 4 o'clock at Care Express?
I would say by noon or
Okay.
1 p.m.
Okay. Are there any other services or anything else that we think we need to add for any of the parents or children in this case?
Let me interrupt you. Mr. Knowles finally made it in the waiting room, so. What type of drug test do you want from mom tomorrow?
We do a hair.
Just hair and UA?
We'll do a hair and UA. And then if we'll go ahead and just have Seth do a hair and Brandon do a UA. We have a recent a hair for Brandon. We'll just knock it all out today for tomorrow.
Okay, hang on just a second. You got ahead of me here.
Sorry, sir.
Give me just a minute. Okay, go ahead, Miss Wildman.
Yes, Your Honor. Is it the department's hope that we may be able to move this case to mediation too at some point?
Yes, ma'am.
Or the case involving Lilly. Now, as far as I had one other question for you. Hang on. Or two other questions. Do you believe the department's making reasonable efforts?
Sorry.
Oh.
I'm so sorry, Judge. Could I interrupt? And I apologize. My daughter's school is is calling me,
okay.
And my husband is not available. So I would just ask permission to step out of the hearing, and I'll come back as soon as I can.
Certainly.
I do not have any questions for Ms. Cantrell, though. If you end up getting done and passing me, I've read the reports. We're fine with the continuation.
Okay. Thank you, Mr.
Thank you, Judge.
Mm-hmm.
Judge, I also have a question.
Yes.
The drug test was supposed to be tomorrow at 1 p.m. I was wondering if I was able to take it at 4 p.m. because
if I have to. Is it Tell me why, because of work or what?
Yeah, because of work.
Okay, yeah, I'll make yours for 4 p.m. tomorrow.
Thank you so much. God bless you, Judge.
Okay. All right.
I just have two other questions, Judge, and then I'll be done. If Ms. Cantrell could answer the reasonable efforts, does she believe the department's making reasonable efforts to reunify with the parents?
Well, let me put it on the record. Mr. Knowles has just now joined us in the hearing, so now you can go ahead.
All right. And Ms. Cantrell, do you believe the department's making reasonable efforts to reunify with the parents in this case?
I do.
Do you believe there's still a continuing danger with reunifying the children with Miss Pelt at this time?
I do.
And just generally, what are some of the department's concerns?
We just have the ongoing concerns of her stability, the income, not knowing, our ongoing concerns with Lily voicing that she does not want to live with mom. She doesn't want to see her in person. It's in her, like I said, it's lack of stability with her.
Okay. And as far as reunifying with and Seth Stewart, what are some of our concerns that still exist, or is it just that we need to get that home study approved?
We just need to get that ICPC done. We need that expedited court order for that ICPC so we can get it done. I don't specifically have any major concerns. We just want to have that, and so we can have continuing monitoring. I know Lily she's anxious, she's ready, she's over all this, she's ready to be with Dad. So the sooner the better.
Okay. Any other updates for the court?
Not that I can think of right now. I'm very proud of Brandon and Seth.
I'll pass the witness, Judge.
All right, thank you. Mr. Turman, any questions?
No questions at all, Judge.
All right, Mr. Michelson?
No questions, Your Honor.
All right, then. Ms. McDaniel?
No questions, Your Honor.
Okay. All right, then. Ms. Wildman, anything further from the department?
No, Your Honor. Just to clarify, the hair and the drug testing for Miss Pelt and Mr. Knowles will be by 1 o'clock. Is that correct?
Well, I'm going to ask Mr. Knowles since he wasn't with us. Mr. Knowles, if you'd unmute real quick. Can you hear me? I can't hear you.
Can you hear me now?
Yeah, I can. Mr. Knowles, they're asking that you do a hair. I'm sorry. Let me look back. A UA drug screen by 1 p.m. tomorrow, where the court usually orders 4 p.m. Can you do it by 1, or do you need till 4?
No, I can do it by 1. That's fine.
Okay. All right. That's all I needed. Thank you, sir. All right, then. CASA. I'm sorry. I don't have recommendations from Ms. McDaniel yet. Ms. McDaniel?
Thank you, Your Honor. In regards to Cora, Your Honor, I feel like her placement with Dad is going well. She seems like she's adjusting the best she can be. Her surgery it is a complete difference in her. She's doing very well with that. So I think her placement there continue, and obviously the court continue to be involved with that. As far as Lily, she is very adamant about what she wants, and I know that his ICPC was not successful. However, I do think that it's probably in Lily's best interest for her to be placed with Dad. He seems like he still continues to have the support of grandmother, which is Lily's current placement. She was very adamant that she wants to be with Dad. She's really over having to talk to all these people. She has, I feel like, improved from the first time I've talked to her. The first time I spoke with her, she was very, very reluctant to talk to me. This time she was very direct with her conversation and told me exactly what she wanted, and that was for her to be with Dad. And she wanted more Zoom visits with Mom, as Erica mentioned as well. But Your Honor, I just feel like what's best for Lily at this point would be for her to be placed with Dad. And again, the court to continue to be involved in that relationship and monitor that. Thank you.
Okay. All right. So I've got a couple of questions then. We talked about the home study was denied, and then some things had to be remedied. I don't have to have a ICPC home study to place a child with a parent, but I would like to hear what was the things that needed to be corrected before we hope it would pass the next time. Ms. Cantrell, is that you?
Yes, let me get my list. Hold on. And it's not, I say a list and that kind of sounds ugly, but that's not. So when we talk about some of the denial, a lot of it does have to do with Lily's ongoing like psychiatric concerns. Let me find this. Hold on 1 second.
Well, while you're looking for that, reading between the lines of the report I read, does Mr. Stewart and paternal grandma, do they live in the same town in Oklahoma?
Yes, sir, they do.
Okay, so they're kind of working with each other already, right?
Yes, sir. And dad goes to grandma's house as long as he's supervised with her. He can, and grandma's supervising, he can regularly go there. So in the and I'm gonna, is it okay to give you the short version?
Sure, yeah. I appreciate short versions
Okay.
always.
All right. So some of it was medication. So, Mr. Stewart's work schedule, he goes to work pretty early in the morning and does work, when she does get out of school. So he had made a plan as far as putting her medication, I'm sure, in a medication thing. And she was going to, take her medicine in the morning and get herself to school on the bus. And so that was a concern that she would be, administering her own medication and getting herself to school. So we addressed that with him as far as I know, many of us, would do that with our own children and stuff like that. But given Lily's, situation, so he did take a psychotropic medication training that all caregivers and even ourselves included here at St. Francis take. We did go over that with him. I sent him a very long email about that. There's also, he did discuss with them about, Lily stopping psychotropic medication, saying, in the future, if she feels like this isn't something she wants to take, he understands that, but he also understands that it's not something that she can just stop. Like it would all be a doctor's recommendation. He fully understands that. I mean, he's willing to discuss that with you today. But he fully understands, like, he can't just stop medication. And he understands that Lily has suffered trauma. She has trauma, the abuse. He understands that. But he knows she's not old enough to dictate her wishes. But he talks a lot about the future and stuff like that. We talked about Lily's daily routine. She's not old enough to do that. And also her mental, where she is. He's already contacted a daycare that does accept children that come in at that can come in at 5 a.m. That would be a routine for her. She would go there, and then she would be go there after school where he would pick her up. They also requested a psychological for Seth. That Seth had talked about some previous diagnoses as a child. But the ICPC suggested a psychological, but it's not required. We didn't request a psychological. He did do that psychosocial. It said that there was no concerns in that psychosocial. I can forward that to any parties as well. And then as far as drug screens, they asked that he be drug screened, but he is drug screening for us. And the screens we have, he has a prescription for that.
Yeah.
And so I mean that there's nothing we can, it's legal where he is. So he just wants the best thing for Lily. He wants him to live the most normal life as she can, and he hates that she's on medication, and he hates, her where she is psychologically and stuff like that. But he fully understands, he can't just turn her world upside down. But I mean, mainly the denial of everything for it has to do with supervision, lack of her ability to take care of herself, and the psychotropic medication concerns.
Okay.
Your Honor,
Yeah.
if I may, I want to bring.
Well, let me make a statement first. I know Lily's got some mental issues, but I don't think I would ever order a 10-year-old be allowed to take her own meds in the morning and get herself to school. So that ain't going to happen. So we're going to have to work around that somehow. I understand. It sounds to me like grandma and dad get along well and they're helping each other out. But I'm just not going to order a 10-year-old take her own meds and get herself to school. So if we can work around what you said, if dad can get her to this daycare before he has to go to work, and if the daycare can administer her meds, I don't know, she's probably not supposed to be taking her meds at 5 a.m. So
Judge, I'm sorry to interrupt. I see Seth trying to respond to that. I don't know if we can.
Well, I'm not through talking yet. I just want to be sure we don't waste a lot of time. I'm not going to let Lily get herself up, get her meds, and get herself to school. So let's spitball around that problem.
And Your Honor, I just wanted to bring to the court's attention that generally, in the past, when a child is placed somewhere where a home study has been previously denied, the other state is no longer willing to facilitate any services or supervision or visitation for the child. So placing without that home study would potentially be an issue with getting Lily those continued services. DFPS has also tended to dismiss those cases immediately, which would, in theory, revert back to any previous orders, which, I believe had Mrs. Pelt having custody of Lily. So I think for the department's request would be that we go ahead and do that expedited home study so that we don't run that risk of the case being dismissed by some administrative closure outside of our control.
Well, do you even know they'll do another one? I've had Oklahoma deny a second home study, an ICPC. I've had them say, we did one, we denied it, we're not doing another one.
Yes, let's see.
And if it's the case, Your Honor, we could hold off to a final to make that decision to place without the home study if necessary, just to avoid any kind of.
Is Oklahoma providing services for Lily?
No, sir. The last sentence of this said, but would not make it a requirement for the psychological would not be required for resubmitting an ICPC request.
Okay. Sounds like they'd go ahead and consider it again.
Yes. I think that none of this was a complete absolute bar for them to resubmit again.
Okay.
So I think we could resubmit again.
That answers a big question. Mr. Stewart, what were you wanting to tell me?
I have written something that I've been thinking about for a long time, because ever since I had got denied that home study, it came to my senses, and it made sense to me also that she is only 10, and to be able to get up that many hours before school is kind of out of line. And it took me heeding to the instruction to learn that. And I'm already have fixed that, fully have. And the medicine thing, I will get a cabinet for it, or not a cabinet. I will get a safe for it and lock it up and get the weekly thing where we will have it already dosed out. And I've also written something that if you have the patience or would allow me to read, I would like to.
How long is it?
Not very long, a couple paragraphs, maybe 2 minutes.
Okay, go ahead. But let me tell you, Mr. Stewart, before you start reading something to me, we're going to have to come up with a plan. Lily's not going to get herself up, take her own meds, and get to school. So if we're not prepared today, if we don't have a plan today, I'll just move our next permanency hearing up pretty quick. We'll get a plan, but it doesn't sound to me like we've got a plan today.
Yeah, we do actually, because my grandma or my mom had told me that I can take her to her house before work, and she will get her to the school, and she will be able to actually give her doses of medicine until the next phase.
Okay, that's what I was hoping somebody would get around to that. I don't know why we were talking about Lily doing it herself or going to a daycare at 5 a.m. if grandma's willing to.
I'm not interrupted. She's going to have full daycare. There's going to be no unsupervision at all until she's older, into her teenage years, when it's like more realistic.
Okay, that's we're getting way ahead of ourselves today. Do you have to be to work like at 5 or 5:30 or something?
I have to be there at 5:50 in the morning. So I would have to take her to my mom's to be able to take her to daycare and get her medication until I get a daycare to be able to just take her straight to every morning.
Okay.
Before school.
All right. I don't need you to read me something.
Okay.
I'm going to set another hearing real quick unless you guys try to iron this stuff out. I'm not ready to change placement. Now, I don't care if you spend, if you spend every hour you're not working with Lily at your mom's house, I don't care. But Lily wouldn't be placed with her if anybody had any concerns. So we may just be kind of splitting hairs here, but I'm just going to set another hearing pretty quick. If y'all can work that out either with the daycare, I'd like to hear Grandma say, yeah, I'll take Lily every morning at 5 o'clock. I'll get her meds. I'll get her to school. That's fine, but I'm not ready to pull the trigger today.
I think he in the waiting room. Her name is Mary Jo. I understand.
There's nobody in my waiting room, and I haven't had a Mary Jo in my waiting room all day long. So
If I could make a request on the behalf of the department, or I could recall Ms. Cantrell, but at this point, Mr. Stewart, I believe all of his supervision is currently still supervised by mom. If part of moving towards, trying to make those plans the court would think it would be appropriate. We would ask that maybe some unsupervised visitation be allowed at this point.
I don't have a problem with unsupervised visits if we're talking about placing him today. So I'll just add that to my previous order that all dad's visitation is unsupervised.
And Your Honor, would it be appropriate to motion for both cases to go to mediation at this time, or would we want to address that after the next hearing?
Amy, have I announced my rulings? Okay, no, I haven't. So mediation's in there.
Okay.
Give me a second. Let me try to make some sense out of what I thought we had and now we don't have. So. Okay. I feel sorry for whoever has to draft this order, but you can always, by tomorrow afternoon, it'll be in Odyssey. You can always get my ruling off of that. So this is not going to be in any great order. So I ought to go off YouTube. This is not one I'm going to be real proud of. All right, let's start with Lily's case. Oh no, I haven't asked for well, I got Tristan's. I have not asked for CASA's, I don't believe. So CASA's, anything y'all want to add before I start rambling?
I am the primary CASA on the case under Janelle's supervision, and we are in agreement with St. Francis in this situation for both Cora and for Lily. I had the same concerns about Dad's supervision of medication and before and after school. Those seemed like they've been addressed, and we're happy with Erica's solutions and Seth's progress on resolving those. I also would like to know what the final plan is, as far as early morning and medication delivery. But once that's in place, we are in agreement.
Okay. Well, I'm gonna move up the next hearing, but I'm gonna allow enough time. Hopefully, y'all could get it into mediation. Give me just a second, and then I'm ready to announce.
And Your Honor, depending on the time frame, I don't think that we would be opposed to the next one being reset as a final either in either case.
Yeah, that's what we'll do. We can always call it a perm when we get there if we're not ready. Do you think there'd be time to mediate and all if I set the next final for June 23rd? I just don't know how long it takes you guys to mediate.
It really just depends on their schedule, Your Honor. It may be better to put it a little bit more towards the beginning of July, because the summer holidays are also going to cause some scheduling issues for parties, I would assume.
Okay. Brittany, are you still here?
Yes, I am looking at July right now.
Yeah, give me something in July.
All right.
And I'm sorry, I know everybody's needing to get out of here. I don't think we'd need
What
a long time.
about the 14th? The 7th, we already have 3 other finals, so I'm kind of not wanting to put it there.
Okay, well, let's just move it to the 14th. Okay, now we're ready.
And Judge, I'm sure everything else. I know you must, but I don't know if you're this. I was
Miss Riley, we can't. You're breaking up terribly. We can't hear anything you're saying.
Don't worry about it then.
Okay, well, now I can hear you. Isn't that the way it always is?
I don't know.
Okay, what were you saying?
I was just saying, I don't know if dealt with it already, but my client just, the only thing I know is I misconstrued. Just want to make sure that the work that
I got everything except the point. You wanted to make sure the court.
The court would would ask to make sure that if Lee is hospitalized again, the client is notified. She didn't know at all, and
We can't, I can't hear you.
I don't know.
I think she may have been asking that she be informed if something happens with Lily again more timely.
Yes.
Okay, well, that should go without saying. So, okay.
Yes.
All right. Let's start again with Lily's case. I will continue the department's temporary managing conservator. For now, I'll continue the current placement with grandma. I'll order mediation. I'll order that Ms. Pelt hair and UA drug screen by 1 p.m. tomorrow. I'll order that Mr. Stewart hair and just hair strand by 4 p.m. tomorrow. I'll order that Mr. Stewart's visitation to be, whatever his visitation is now, to be unsupervised, and he can have any additional visitation supervised by placement, meaning grandma. In Cora's case, I'll continue the department's temporary managing conservator, continue her current placement with dad. Mediation will be ordered in that case. Again, I'll order Ms. Pelt to hair and UA by 1 p.m. tomorrow, and I'll order Mr. Knowles to hair and UA by 1 p.m. tomorrow. Okay, in both cases, I'm going to set the final for July 14th, 2025. It will be by Zoom like today's hearing. Parties and attorneys can go on the court's online docket a day or two in advance to see exactly what time that will take place. And I forgot to order, I'll go ahead and order another expedited home study on Lily's case. Let me get that now before I forget it. So I'll order an expedited home study on Mr. Stewart again. Okay, Ms. Wildman, I don't know who drafts your orders, but like I said, by tomorrow evening, this will be an odyssey and I'll kind of clean it up so y'all can figure out what I said today.
That was a lot clearer than you led us to believe, Judge.
Okay, those were our last hearings for the day, thank goodness. So we will stand in recess. Everybody have a good week.
Thank you, Judge.
Thank y'all.
Thank you, Judge.
Thank you, Honor.
Amy, thanks.
Thank you, Judge. I'll see you Wednesday.
All right, see you Wednesday. Brittany, you gonna take off?
Yes, I'm about to take off right now.
Okay, all right.
Have a good evening.